Good morning and welcome. My name is Terrence Carter and I'm the managing partner of Carter's. It's my great pleasure to be a co-host for today's annual charity and not-for-profit law webinar, which continues the tradition of serving the charity and not-for-profit law sector through seminars and webinars every year since 1994, making this our 32nd year. A big hello and thank you to all of our loyal repeat attendees, as well as to first-time registrants, including many of you from across Canada. It is a privilege to have more than 1,270 of you join us today, as we know your time is valuable. I'm very happy to have Ryan Prendergast, a partner and specialist in charity and not-for-profit law in our Orangeville office, join me today as co-host. Ryan.
Thanks, Terry. I'm delighted to be able to join you today. Before we begin, I'd like to take a brief moment to acknowledge the traditional territory of the Anishinaabe people, including the Ojibwe, the Potawatomi, and Ottawa of the Three Fires Confederacy, from where Terry and I are located in the Orangeville office, as well as the traditional unceded territory of the Algonquin Anishinaabe people for those speakers in our Ottawa location. And for Toronto, we wish to acknowledge the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, and the Chippewa, amongst others. When we used to gather in person for this webinar, we would start things off by singing O Canada together. And so the webinar format doesn't allow us to do that anymore, but that shouldn't stop us from celebrating how fortunate we are to live in Canada as the true North, strong and free. As we just recognized Remembrance Day, we remember those who have given their lives for our country and for the thousands of men and women CAF service members across Canada who keep us safe. Thank you.
Today's webinar is intended to provide practical information on current legal issues for charities and not-for-profits to help mitigate against unnecessary exposure to legal liability. There are 10 really good, fast-moving topics being presented today by a lineup of very qualified speakers that charities and not-for-profits will no doubt find relevant to their work and helpful. Please refer to the short bios of each speaker and the link to the event resources, as introductions of speakers will be kept to a bare minimum, and you will find the agenda for the day there as well. It's important to point out that the information provided during this webinar does not constitute legal advice. And as such, attendees encouraged to seek assistance from their own legal counsel before making decisions based upon information provided during this webinar. You're encouraged to subscribe to our free charity and not-for-profit law update, published 10 times a year through our website at carters.ca. It's a great way to keep current on changes in the law. Please note that an on-demand replay will be available to all registrants and only registrants after the webinar by Monday of next week. A post-webinar thank you email with the link for the on-demand replay will be available until the end of January 2026.
Although I and many of the lawyers in our firm are excited to be speakers today, we would like to take a moment to thank our special guests, Bruce McDonald, President of Imagine Canada, and Kenneth Hall, President of Robertson Hall Insurance, for joining us for our fireside chats today.
On behalf of the team at Carter's, we'd like to thank our sponsors who have made it possible for us to have Event Stream Productions assist us with today's webinar. Thank you to our gold sponsors, Adams & Miles, LLP Chartered Professional Accountants, M&P Accounting, Consulting, Tax and Digital Services, Robertson Hall Insurance, and Thomson Reuters. Thank you as well to our silver sponsors, Beacon Endowment Solutions, as well as LexisNexis. Information about our sponsors is included with our resource materials, and we encourage you to review the information about them and visit their websites to learn more about what they have to offer. Please also see links for our sector resources at Event Resource button on your materials for the CAGP, Canadian Association of Gift Planners, Canadian Centre of Christian Charities, Imagine Canada, and the Ontario Nonprofit Network, ONN.
And as if today wasn't exciting enough already, a draw for books that lawyers at our firm have co-authored or contributed to, or maybe worked on while they were articling, will be held after the question period at the end of the webinar, so you'll want to stick around until the very end. These books are the Thomson Reuters has provided one copy of the Corporate and Practice Manual for Charitable and Not-for-Profit Corporations, a 4-volume voluminous set. LexisNexis has also provided one copy of the 2026 Charities Legislation and Commentary, which isn't even out yet. So if you win that, you'll have to wait until mid-December in order to get that book. One copy of Branding and Copyright for Charities and Nonprofit Organizations, and one copy of the Management of Nonprofit and Charitable Organizations in Canada. As well as the books, we also have 4 gift cards for $100 for the Canadian Centre for Christian Charities store. So you want to stick around for those as well.
So next up, we're going to briefly review some of the technical aspects of the webinar. This is a great opportunity to get on top of your technical game. So Ryan, what if it turns out that I need technical support?
So don't panic, take a deep breath. If you require tech assistance at any time, click on the help icon at the far right side, just below the video screen. Click on it and then click chat with support and ask your questions. The event stream tech support will respond to you in that help box.
Okay, good. And Ryan, can you tell me, how can I get the materials, including the agenda and PowerPoint slides?
So Terry, same thing, just go to the right side of your screen and you'll see the files icon, which looks like a download icon. There you'll find the agenda, the handout package, and the speakers' bios, as well as Carter's resources, our sponsor resources, and sector resources, as well as the applicable CPD credit receipts, which are going to be very important. Also available in the files area is a newly updated 2025 legal risk management checklist for Ontario-based not-for-profits and charities. We have heard some people say that they're repeats or that they're both the same. They're not. It's intentional that there's supposed to be 2 different checklists there for you to review.
Thanks, Ryan. Yep, charities are different from nonprofits, but they have a lot in common. So thanks for pointing that out. Can you tell me how do the attendees send questions to the speakers?
No problem. We encourage the audience to submit questions at the end of the presentations rather than at the end of the sessions. So while speakers are speaking, if you have a question that comes up, please just enter it in and we'll work on getting towards that at the end. Please click the question mark icon located below the video screen, enter the name of the speaker first, followed by your question, and click submit. Unfortunately, we won't be able to get to everyone's questions today due to time constraints, but we do encourage you to ask them.
Okay, next question. How does the audience provide feedback?
Well, since we're doing this as a webinar format, they'll need to refrain from throwing tomatoes or other vegetables. However, after the webinar, attendees will receive a thank you email that will contain a link to a survey where you can give your feedback on the webinar and how we might improve for next year. We always appreciate the feedback.
Okay, and so what can I expect with regards to the flow of the day? It's a long day, 4 hours. So what can I expect, Ryan?
Well, Terry, as you mentioned, the presentations are 10 fast-moving sessions at 20 minutes each, except for our 2 fireside chat speakers who will have 25 minutes respectively. The lawyers will answer questions at the end of the webinar. The PowerPoints are intentionally content-rich and intended to be a useful takeaway resource tool for future reference.
Okay, the big question, Ryan, I'm going to have enough time to tell a few jokes.
Absolutely, Terry. You will have 5 minutes after the 10-minute mark of the 15-minute coffee break to tell your jokes, provided you've actually chosen some funny ones for a change.
Right. I have chosen the very best. I have worked on them all year. So you don't have to stay around. You can do other things during that period of time. But if you wish to join in, you would be more than welcome at the 10-minute mark of the coffee break. So thank you for that. Well, we're already 1 minute ahead of schedule. This is great. And we're going to go into our first session together. It's our tradition to try to provide an overview of what's happening in the charity not-for-profit area. So we're going to start off with our first session, Essential Charity Law Update. And Esther Shaneblum is at our Ottawa office, a partner in the area of charity and not-for-profit law and privacy. And Urshita Grover is an associate with our Orangeville office in the area of charity and not-for-profit law. We look forward to hearing your comments. Over to you, Esther and Urshita.
Thanks, Terry, and good morning, everyone. So it's exciting to be the first ones up. We're all motivated to keep you awake. So we have a lot to cover in 19 and a half minutes, as Terry was saying, so we will not be speaking to everything in the slides. You're going to have them as a resource for later, and we have included all the links to the source documents if you want to look up anything else. So we're going to just go right into it. As you know, the federal budget came out on November 4th, and it included a number of measures that are relevant to this sector that we're going to briefly review. The first item we want to bring up is the change in reporting requirements for NPOs. And when we say NPO, as Terry alluded to, we're referring to nonprofit organizations rather than charities. They are different. These measures that were announced will add new reporting requirements to NPOs that were previously not required to file the Form T1044 nonprofit organization information returns. So the budget has announced that the government is going to proceed with previously announced amendments to the Income Tax Act that will require two things will happen. One, NPOs will be required to file a Form T1044 if they have gross revenues over $50,000. And the second thing that is going to change is that NPOs with revenues below $50,000 will have to file a new annual short form information return that will include certain prescribed information, such as a description of the NPO's activities, whether it has activities outside of Canada, its name, mailing address, and the name and address of every director or officer. So the budget defers the effective date of these changes to January 1st, 2027, rather than 2026, which was the original effective date, while the government reviews stakeholder feedback. But we wanted to make you aware of this now because you need to be aware of these requirements. If you are an NPO that was previously exempt from filing, that may change. The next item we want to raise is the confirmation in the budget that the federal government intends to proceed with a number of measures that were previously announced at many different times between 2021 and August 2025. Among other things, the budget says that the government will proceed with, quote, legislative and regulatory proposals announced in the 2024 Fall Economic Statement, including with respect to the following measures, and then a few measures are set out. So we infer that the use of the word labeling suggests that this is not a finite list, but it isn't clear from the budget which measures are intended to proceed. Some of the measures in the 2024 Fall Economic Sector are relevant to the sector, including extending the period for which qualifying foreign charities are extended status as qualified donees, making some administrative changes to the ITA to modernize certain services, and expanding the CRA's audit and information gathering capabilities, among others. But it is not clear which will proceed, if any. It is also not clear how the measures that do proceed will be modified, as indicated in the budget, to reflect the consultations and deliberations that it refers to. So we're all going to need to wait and see how this plays out in the next few months. The next item we want to mention is the issue of trust reporting under the Income Tax Act and regulations. You may have heard about this before. This is a complicated issue and has a complicated history. Briefly summarized, essentially amendments to the trust reporting rules were originally proposed back in 2022 that would require previously bare and express trusts to file a T3 annual income tax return for taxation years ending on or after December 31st, 2023. The CRA then came out with a few exemptions, and then subsequently those were followed up by draft legislation released in 2024, but that was never introduced. And then subsequently, another set of draft legislation came out in 2025. So the budget now announced that the government intends to proceed with the 2025 draft legislation, but that the effective date will be deferred the effective date for reporting by bare trust, will be deferred to taxation years commencing on or after ending on or after December 31st, 2026. This is a very complex legislation and did leave us with a lot of unanswered questions when it came out. So it is hoped that there will be some clarification on these provisions before they come into force. So now I'm going to hand over to Urshita.
Thanks, Esther. Continuing on with Budget 2025, it introduces measures to strengthen Canada's anti-money laundering and anti-terrorist financing framework with implications for charities and not-for-profits handling financial transactions. Key initiatives include creating a new federal agency as the lead enforcement body for complex financial crimes and amending the Proceeds of Crime, Money Laundering, and Terrorist Financing Act and its regulations. These updates build on earlier legislative efforts like Bill C2 and C12 focused on tightening border and financial security. Under the proposed changes, accepting cash payments or donations of $10,000 or more, or accepting third-party cash deposits from one person to another's account would be prohibited. Given these proposed prohibitions, charities will require donors to use traceable payment methods like checks or e-transfers for large gifts. These proposed amendments will apply to all financial donations, regardless of whether they're considered charitable, signaling a broader AML/ATF scope for financial giving. The budget also proposes amendments to certain federal acts, such as the Canada Not-for-Profit Corporations Act, to allow for the expedited dissolution of corporations which have been designated as terrorist entities. Next, Budget 2025 and its pilot program also proposes a legislative amendment to the Customs Tariff Act that will allow a duty drawback, which is essentially a refund on domestic duties for certain goods donated to registered charities. This refund only applies when the donated goods are used directly in charitable programs and not resold in Canada. The goal is to support charities and low-income individuals who rely on charitable services for essential items like clothing or household goods. CBSA defines obsolete goods as outdated or no longer useful items, such as typewriters or expired medication, and surplus goods are defined as excess inventory like seasonal or event-specific products left over after their demand has ended. Our next topic covers some CRA updates. CRA issued an updated version of their guidance on relief of poverty and charitable registration on October 23, 2024. The guidance provides comprehensive direction on how charities and applicants can meet Canadian common law and ITA requirements related to the charitable purpose of relief of poverty. A key addition in the updated guidance is the expanded section on determining eligibility for affordable housing within a specific community or area, making possible use of provincial or municipal criteria consistent with federally funded affordable housing programs. For instance, a household seeking 3-bedroom accommodation in Toronto in 2024 needed to meet the $79,000 income thresholds to qualify. Now, this slide here includes additional CRA and items of note. First, the Charities Directorate released its report on October 1st, 2025, which outlines its activities, achievements, and ongoing initiatives from April 2024 to March 2025. Next, the National Security and Intelligence Review Agency released a report discussing the findings of their review of CRA's Review and Analysis Division, referred to as RAD, which made clear that there were concerning discrepancies in the RAD's auditing process and proposed a number of recommendations to address them. In response to which, CRA will review its audit program to determine what improvements can be made. More recently, the Canadian Association of Gift Planners released a guide and companion resources to enhance an understanding of donor advised funds, which is one of the fastest growing areas of charitable giving in Canada. Now, a quick look at some provincial legislation. Ontario's Bill 16, an act respecting the safe access to religious institutions, was introduced and completed first reading on May 8, 2025. If passed, Bill 16 would prohibit activities within designated access zones intended to dissuade or obstruct individuals from entering religious institutions such as a church, mosque, synagogue, temple, or a cemetery. Enforcement mechanisms include fines, imprisonment, civil remedies, and provisions for court-ordered injunctions. However, individuals cannot be convicted unless they were aware or notified of the access zone boundaries. The legislation also grants the Superior Court authority to issue restraining orders and allows for warrantless arrests in certain circumstances. The federal government also introduced a bill on protecting communities against hate in September of this year, which will be covered during a later presentation today. On October 31st of this year, the Ontario government also announced plans to create the Ontario Provincial Conservation Agency, which will consolidate the current 36 conservation authorities into 7 regional ones. The goal is to streamline environmental approvals, make permitting faster and more consistent, and help conservation authorities focus on managing watersheds and protecting communities from floods. Legislation will be introduced soon, followed by public consultations on the new regional boundaries. Next, we're going to talk about some cases relevant to charities and NFPs. The first case was decided on May 21st, 2025, and involved the Roman Catholic Episcopal Corporation of St. John's, whose bankruptcy proceedings were converted to CCA Act and is in the process of selling assets, including the church in Portugal Cove South. The local residents opposed the sale, arguing their significant efforts and expense in renovating the church entitled them to an equitable interest in the property of the church. The court rejected this claim, finding no valid trust or unjust enrichment. First, there was no evidence of a clear intention to create a trust, there was nobody to maintain the trust, and the Roman Catholic Corporation was not even aware of the alleged terms of trust involving what was donated. Second, since the contributions by parishioners were made with donative intent, meaning they didn't expect repayment, the claim of unjust enrichment failed. Because residents tried to block the sale, including changing locks and preventing access, the court found they committed or threatened torts like trespass and interference with economic relations, and so the court issued a permanent injunction against further obstruction. The key lessons to be learned here include to always document property ownership clearly, defining nature of community contributions upfront, and for faith-based organizations, it is vital to manage community expectations about property ownership and disposition of assets. Now, over to you, Esther, to continue with the remaining cases.
Thanks, Urshita. The next case is an interesting case that was decided in June by the Ontario Court of Appeal. This case involved 2 corporations, a Canadian corporation, the Islamic Food and Nutrition Council of Canada, and an American corporation, the Islamic Food and Nutrition Council of America. The Canadian corporation was incorporated under the Ontario Corporations Act, and then it had bylaws that were enacted in 2015 that created 2 classes of members, one voting class and one non-voting class, and made the U.S. corporation the sole voting member. In 2021, the Canadian corporation obtained articles of amendment articles of continuance under the federal CNCA, the Canada Not-for-Profit Corporations Act, that actually created 1 class of members, each of whom were voting members. There was no evidence that the U.S. corporation had ever been notified of the articles of continuance. Subsequently, following a dispute, the Canadian corporation went to court to seek a declaration that there was only 1 class of voting members in accordance with the 2021 articles of continuance. The U.S. corporation, in turn, requested a court declaration that the 2015 bylaws were in force, that there were still 2 classes of members, 1 voting and 1 non-voting, and that it was the only non-voting member, or rather the only voting members. Sorry about that. The U.S. corporation succeeded at the first instance. The application judge found that the 2021 articles of continuance were ultra vires and invalid because there had been no special resolution of the member to approve them, which is contrary to the requirements of the CNCA. As a result, the U.S. corporation remained the sole voting member. The Canadian corporation then appealed this decision to the Ontario Court of Appeal, which agreed with the application judge and dismissed the appeal. So the big takeaway from this case is always comply with the basic requirements of the governing legislation and the bylaws when making changes to corporate documents. The next case is the Horley Estate case, which came out in June as well. It was decided by the Nova Scotia Supreme Court. In this case, the testator had made a specific bequest in her will to a specifically named church. But by the time of her death, the parish in which the church was located had sold that church property and then had amalgamated with another parish and had a new name. So the court had to decide whether the gift could pass to the amalgamated parish as the successor of the original church, or whether it had to save the gift under the CPRE doctrine. The court found that the two parishes had voluntarily amalgamated and lived on as the amalgamated entity, and therefore there was clear organizational continuity, so that the amalgamated entity was the proper successor and could receive the bequest. The court also said that the gift would have been saved under the CPRE doctrine anyway, because the testator's intent was to support her congregation, which now worshipped at the amalgamated entity's premises. So takeaways from this: if you are a lawyer acting for testators, or if you're a testator, it's important to regularly confirm the status of charitable beneficiaries, because they often may amalgamate, dissolve, or change names over time. And having worked in a charity, I can attest to that. When you receive a bequest that was drafted 35 years ago and the entity is not the same anymore. So in addition, and to avoid disputes and uncertainty, it's advisable to include wording like "or a successor organization" when you're drafting wills. Okay, our last case, this is a big one. It's complicated, so we'll just briefly run through it. This is the case of Priority Foundation versus Canada, which went to the Federal Court of Appeal and was decided on October 7th. And it basically turns on the interpretation of Article 21.7 of the US-Canada Tax Convention, which I'm sure you're all really familiar with. So Priority had made gifts to non-qualified donees, which were US 501c3 charities. And as a result, its charitable status was revoked. Priority appealed CRA's decision to revoke its charitable status to the Federal Court of Appeal, arguing that the CRA was wrong in law about its interpretation of Article 21.7, which states that for the purposes of Canadian taxation, gifts by a Canadian resident to a U.S. tax-exempt entity should be treated as a gift to a registered charity. So Priority's view was that this means that a gift to a U.S. charity has to be treated as a gift to a registered charity under the Income Tax Act of Canada. And CRA's interpretation was that Article 21.7, yes, agrees gifts to a U.S. 501c3 to be treated as gifts to a charity for the purposes of reducing your tax liability in Canada, but that does not mean that the U.S. entity becomes a qualified donee under the Income Tax Act for the purposes of retaining charitable registration in Canada. The federal court really essentially agreed with Canada Revenue Agency and found that a gift, that the Article 21.7 allows a gift to a U.S. 501c3 to be treated as a gift to a registered charity for tax relief purposes, but that does not mean that it's a gift to a qualified donee, or that the recipient is deemed to be a registered charity in Canada or a qualified donee. So therefore, CRA had acted properly in revoking Priority's charitable status, and the appeal was dismissed. So this case does provide important consideration of this Article 21.7, which has been unclear for a number of years. It also shows us that qualified donee status is limited to entities recognized under Canadian law and is not dealt with under the tax convention. And it further points out that gifts to foreign organizations such as US 501c3s do not qualify as disbursements to qualified donees unless there's some specific recognition as a qualified donee under the Income Tax Act. So you need to be aware of that if you are a charity. And that takes us to the end, and we have made it, 25 seconds to spare, Terry. So I hope that is great news for you.
Well, thanks so much, Esther and Arshita. It's amazing. You'd think in the area of charity not-for-profit law, not so much could happen within a year, but every year we always have a critical update on lots of case law and things changing with CRA. So that's one of the exciting things about getting to help people in charities and not-for-profits and having to always keep up on these changes. So thank you. Now, to move on with the program, I'd like to introduce Jackie Dempscher and Jefe Olaganjo to talk about the topic of charitable registration and purpose amendments. So Jackie is a partner at Carter's Professional Corporation working here in our Orangeville office, and Jefe is one of our newest associates. Both are practitioners in the area of charity and not-for-profit law. So I'll turn it over to Jackie and Jefe.
Jefe and I, good morning, are going to be speaking to you about two topics today. You'll see here on the slide. The first topic is navigating charitable registration, which Jefe will speak to, provide some introductory comments, deal with first-time applications for registration, re-registration if your existing charity is revoked, as well as reviewing the application process that the CRA follows. And the second half of the presentation, I'm going to be speaking to you about navigating purpose amendments for existing charities. We're going to talk about why an existing charity may amend its purposes, how to do the drafting process, how to do the formal amendments of the purposes under the governing legislation, as well as the CRA approval process. And we'll finish up with some key takeaways. So I'm going to turn the presentation over now to Jay, and who's going to speak to you about navigating charitable registration.
Thank you, Jackie. I'm going to walk you through how to get registered or re-registered as a charity with the CRA. Think of it like building an IKEA bookshelf. You know what the finished product should look like, but even if one piece is out of place, it wobbles and drives you crazy. Setting up your organization right piece by piece will help you achieve your mission and focus on what matters most. Whether you're just starting out or you're an established charity or you're trying to rebuild after a revocation. We'll start by looking at organizations applying for charitable status for the first time. For first-time applicants, understanding the requirements for charitable registration is key, as it is not enough to do good. You have to do good in a way that is recognized under the Income Tax Act and by the CRA. To be eligible, you have to be a legal entity resident in Canada, established for exclusively charitable purposes under one or more of the 4 categories of charities, devote all resources to charitable activities, maintain direction and control, meet the public benefit test, and avoid directly or indirectly supporting a political party. Any organization that meets the eligibility requirements just discussed can apply for charitable registration. Now, we know the requirements to apply, but what are the benefits and obligations of charitable registration? Once registered, you can issue donation receipts. You are exempt from income tax. You can receive gifts from other registered charities in Canada, and you gain credibility. However, to quote Uncle Ben, with great power comes great responsibility. Being a registered charity comes with obligations, and it's important to follow them. Failing to do so can lead to penalties or even revocation of your charitable status. On the next slide, I will review the legal structures organizations can consider. Charities can be set up in a few different ways. They can be corporations, trusts, or unincorporated associations. Each structure has its own pros, cons, and limits. When deciding on a structure, the key is to pick one that supports what the organization is doing now and gives it the flexibility to grow and adapt in the future. In most cases, we recommend incorporation. It offers limited liability for members, provides perpetual existence, allows directors and officers to be indemnified, and makes the organization a separate legal entity from its members. Next slide, please. The CRA recognizes 3 types of registered charities, and the main differences really come down to how they operate and who sits on their boards. For charitable organizations, they usually run their own programs or activities, and more than half of their directors have to be unrelated, so they're not connected by blood, marriage, a common law relationship, or a business relationship. Public foundations typically fund other qualified donees, and they have the same rule. More than half of the directors must be unrelated. Private foundations, on the other hand, often do a bit of both. They might fund other organizations and run their own programs. The key difference here is that half or more of the directors are related by blood, marriage, common law partnership, or a business relationship. In addition, over half of their funding comes from individuals with some degree of control over the charity. Moving now to drafting charitable purposes. What are some important considerations? Purposes must be exclusively charitable and clearly define the scope of your activities. Each purpose should include 3 key elements. The charitable category, for example, the relief of poverty. The means of delivering that charitable benefit, for example, operating a soup kitchen. and the beneficiary group who will receive that benefit. For example, individuals experiencing homelessness. It's important to find the right balance in your wording. Purposes that are too broad or too vague might not qualify for registration, while purposes that are too narrow can end up restricting what your organization is able to do in the future. A good starting point is to look at the CRA's examples of charitable purposes. You can either use those directly or tailor them to fit your organization's specific goals and activities. On this slide, you'll see few CRA-approved examples of charitable purposes, one for each of the 4 categories. These examples are really helpful when you're trying to figure out how to word your own purposes or check if yours fit within the CRA's framework. If you want to dive a bit deeper or see more examples, there's a link to the CRA's website on this slide where you can explore this further. So after deciding how your organization will be structured and completing that process, the next step is to apply for charitable registration by completing the CRA application form. You can access the application form online through the CRA's My Business account, which is now the default way to apply. If your organization still prefers to use the paper application, you will need to contact the CRA. The application form has 13 sections, which you can see listed on this slide. Each section needs to be completed carefully and accurately. You can fill it out yourself, or you can authorize a legal professional to complete it on your behalf. Now, while it's important to get the form right overall, there are 3 key parts of the application that every organization should pay attention to. First, the statement of activities. This needs to be detailed and realistic and include all the information the CRA is looking for. Next, the budget should include a detailed breakdown of all expenses for each activity. Then you must provide all the supporting documents the CRA asks for. In addition, ensure publicly accessible information on the internet regarding your organization, your programs, your directors, officers, match the information you're providing in your application. Inconsistencies may raise questions. The effective date of registration is usually the most recent of the dates listed here. So we've looked at first-time applications. Now let's look at re-registration after revocation. The most common reason charities lose their status is failing to file the annual T3010 return. In the 2024 to 2025 fiscal year, there were over 2,000 revocations, and more than half were for failure to file the T3010. If a charity is revoked, there's no reinstatement process. You have to submit a brand new application for re-registration, showing that your purposes are charitable and your activities support those purposes. The fact that an organization qualified for registration years ago does not guarantee it will qualify for registration today. Before applying, you'll need to file any missing T3010s, submit financial statements, pay the $500 late filing penalty. You also have to meet all current CRA requirements. If you reapply and are re-registered within 1 year, you can avoid the revocation tax. But after 4 years, the CRA treats it as a brand new application. Re-registration can be challenging, from missing corporate documents to governance gaps or delays in getting charitable status and inability to issue donation receipts. It is usually a time-consuming and expensive process. The good news is it is completely avoidable in most cases by ensuring the T3010 gets filed on time annually. The board should ensure it follows up on this even if the filing task is delegated. The effective date of re-registration for revoked charities is the date of revocation. After submitting your application, the CRA reviews the application. And once your application is submitted and they review it, you will get an acknowledgement letter confirming receipt and giving an idea of the expected timeline. If anything is missing, the CRA will return the application without processing it. Next, your file waits to be assigned to a CRA analyst for detailed review. During that review, the CRA might ask for more information or documents. This could come as a phone call or an administrative fairness letter.
thank you very much, Jay-Fei, for your
No
comments.
worries.
It was very, very helpful and informative. I'd like to speak to you now about existing charities navigating amendments to their charitable purposes. The first question is, why would a charity need to amend its charitable purposes? There's a list of reasons set out on this slide, but some of the main ones include a charity having to change their purposes in order to realign programs that have expanded outside the existing purposes because of an evolving mission focus. Sometimes charities set up at the beginning, as Jay-Fei mentioned, with very narrow or restrictive purposes, and that limits the flexibility they have in carrying out new programs. As well, some charities establish brand new programs, and they need to have their purposes catch up and give them the authority to carry out those new purposes. The key here is making sure that the purposes that your charity has are updated and expansive enough to provide you with sufficient corporate authority to carry out all of your day-to-day programs and activities. Usually a review of your charitable purposes is driven by a couple factors. Sometimes you have new board members or new senior management that comes into the organization, and they bring fresh eyes to the charity's governance documents. Alternatively, when we are consulted with charities on a specific issue, we'll go back to their corporate documents and their purposes as a starting point in understanding the organization, and sometimes issues with historic charitable purposes come up in that context. So once issues with the purposes have been identified, the board needs to review the situation, understand what they need to do, and authorize proceeding with the drafting of new purposes. So how do you do that? Well, you need to go back to the basics. Charities need to put together a detailed summary of all their day-to-day current programs and activities, as well as the future ones they wish to engage in. This may be an easy task for a small charity, but more difficult for a larger charity with a broad scope of programs. Once you have all your programs identified, you want to organize them into program categories or themes. You may have some that are under advancement of education, some under relief of poverty, some under the fourth head of charity that has a number of subsections. And you want to organize them in this way so that you can then review all of the applicable CRA policy guidances related to those categories. This helps you understand CRA's compliance requirements in each of those categories, as well as the acceptable wording that CRA has for the proposed new purposes to be drafted. You want to draft new purposes at this point. You want to make sure that all of your programs fit under one or more of those purposes. And Jay-Fei has spoken to you about how the purposes need to be drafted. They have to be charitable in nature exclusively, not broad and vague. I would really encourage you, as you start this exercise, probably better at the beginning than in the middle or the end, is to seek legal advice in the drafting process. This is especially important where there's a significant purpose redrafting going on. Reaching consensus within your own charity internally on these new purposes will be, it'll be a big project. Multiple drafts likely need to be prepared and go through different people in your organization, as well as back and forth with your legal counsel. And you want to strike the right balance between legal compliance and the operational realities. You want the new purposes to really reflect your charity's mission. Once they're in close to final form internally, they're going to go through a review process within your charity. If senior management has led the project with legal counsel, you'll want to bring the purposes first to your governance committee if you have one, then over to the board for its review and input. And if your charity has an open or broad-based membership, you're going to need approval of your members. And usually we recommend circulating them ahead of time so that members have an opportunity to review and digest them, and possibly holding a town hall to get members' feedback. Once internally the purposes are satisfactory to everybody involved in your organization, the next step is to formally put them in place by amending your corporate documents. I've assumed on this slide that your charity is a corporation, and a charitable corporation would put the new purposes in an application for articles of amendment. It would need to get formal board approval, followed by formal membership approval at a special meeting of members that's called. Everything gets signed up, and then depending on your jurisdiction, you file it with your particular corporate regulator. For charities that are located in Ontario, You need to know that the public guardian and trustee is another regulator that you'd have to deal with. And you deal with them in the amendment of purposes in the context of what's called an after acquired property clause. Any Ontario charitable corporation that changes their purpose has to include automatically this after acquired property clause, save and except if you can get a written consent from the PGT to exclude it. And you can obtain that consent if your amended purposes are consistent with your historic ones. Before, though, you take the step of formally changing your purposes, you want to consider how you want to deal with the other important regulator here, the CRA. To get charitable status, you had to get CRA's approval of your purposes. If you change your purposes later in the life of your charity, you've got to go back to CRA for approval. You have two options in getting this approval from CRA. Option one is before formally changing your purposes in your corporate documents, you go to CRA and seek pre-approval of your draft new purposes. You do that by submitting the draft purposes to the CRA through your My Business account, together with an updated statement of activities. The advantage of option one is that you will have certainty from the CRA that the new purposes that you've drafted are satisfactory to them before you formally put them in place and you can start to operate under them. The disadvantage is that it takes time for CRA to get to your request and to review your draft purposes and provide you with their feedback. Often this takes 4 to 6 months, but it will depend on your CRA processing time at the time you submit them. Option two is not to seek pre-approval from CRA. Instead, you go ahead and formally amend the purposes in your corporate documents, and you submit your certificate of amendment to the CRA through the MyBA again, but under the amending governing document option. You'll submit your statement of activities with your certificate of amendment. Again, you're going to wait for CRA to review and process your request. The advantage of option two is that you will immediately have an expansion of your corporate authority to carry on your current charitable programs and activities. The disadvantage is that once CRA has an opportunity to look at your new purposes, they may come back and ask more questions about your programs or activities, and they may actually ask you to amend those purposes further. And that would require a second application for articles of amendment. So just to conclude, some key takeaways here from our presentation. If you're a new charity seeking charitable status, you want to do your homework to prepare the best possible application for charitable status that you can. You may consider retaining legal counsel to assist from the outset, as opposed to bringing them in later in the process if you run into difficulties with the CRA. For existing charities, you want to avoid having your charitable status revoked for all the reasons that Jay-Fay explained. You want to avoid that happening, particularly because of late filings of T3010s. Re-registration is long and cumbersome and can negatively impact your organization's reputation with your donors. You want to, as an existing charity, do regular reviews of your charitable purposes to ensure that they are up to date and you have full corporate authority to carry on all your day-to-day programs and activities. And finally, you want to ensure that the regulators, the CRA in particular, receive and approve your charity's amended purposes. And in Ontario, you want to avoid having to include the after-acquired property clause in your certificate of amendment, if at all possible. So that concludes our comments for today. I hope you found it informative and you enjoy the rest of today's webinar.
Well, that's great, Jackie and Jeffy. Thank you so much. And I like the analogy over to an IKEA building a cabinet. That was great. Much appreciated. Now we're going to move over to Barry Kwasniewski. Barry is our employment counsel and has been presenting with us for many, many years. He's a partner in our Ottawa office. We've asked Barry to speak on the topic of, quote, starting off on the right foot, legal considerations in the hiring process. So Barry, delighted to have you and look forward to your comments.
Good morning, everyone. Welcome to today's presentation on employment law. I hope everyone who's a baseball fan enjoyed the Blue Jays run to the World Series. One thing that I learned in watching many hours of baseball is that baseball is more complicated than law. After reading a legal case, for instance, I can usually understand the gist of it, but I still don't understand the difference between a slider, a cutter, a fastball, a changeup, and a curveball. So on with the show. So the changes in the law over the past year have caused me to consider this topic as relevant for charities and not-for-profits, particularly in the hiring and the onboarding process. There's been a lot of changes. So in my time today, I'm going to discuss these changes and hopefully give you some useful information. In Ontario, the Employment Standards Act has been amended starting in January 2026. The way you advertise for positions is going to be changing significantly. There are new job posting requirements in Ontario for employers which employ 25 or more employees. And these are going to change the way you need to advertise for a job. Now, these apply to publicly advertised job postings, means that are advertised to the general public, not an internal posting. So what is important to know is that you need to know that all these issues on the screen will need to be considered in your job posting requirements. I just want to highlight a couple of these. It's important to note that you must disclose if the posting is for an existing vacancy or not. This is because there has been a problem in the past with employers advertising for jobs that did not really exist. So in order to avoid that situation, you have to disclose if the posting is for an existing vacancy. Now, also importantly, you cannot include requirements related to Canadian experience. So this has come into force because the government of Ontario thought that many new Canadians were being shut out of potential jobs because of Canadian experience requirements in job postings. So you can no longer require Canadian experience. Of course, you can require proof that the person is eligible to work in Canada, but the Canadian experience requirement we've seen before is no longer allowed. Now, with respect to applicants being interviewed, you have to inform the applicant if a hiring decision has been made within 45 days of the interview, or if there are multiple interviews, the date of the last interview. Now, I want to talk about AI in the hiring process. Now, part of these changes are requiring employers to disclose whether AI is used to screen or assess or select applicants for the position. Now, as we know, AI is entering into numerous areas of professional and personal lives, and including the human resource function. Now, I don't know how many of you out there in working for charities and not-for-profits have considered using AI in the hiring process, but if you do, you have to disclose that in the job advertisement. One issue with AI is that there are potential problems to consider because it is so new, and you want to avoid issues about the interview process being carried out by AI, for instance, as this can cause you problems in terms of potential biases in the questions that are being asked in the applicants and other issues that relate to the technology itself. So if you're considering using AI in the hiring process, be careful and do your homework as to what should be done and not done. Martin and Cameron will be talking more about AI later today, which I'm sure will be very interesting. Now, in force as of July 1st of this year was another requirement that affects the hiring process. On the slide, you'll see the information that needs to be provided to employees either on their first day of work or reasonably thereafter. So you have to include this basic information for employees who are starting work. This has come into effect because in numerous instances, employees weren't given sufficient information about the organization, even the legal name of the employer or the operating name or business. So this applies to organizations with 25 or more employees, including charities and not-for-profits. Now, employment contracts are important as well because the use of employment contracts is important because it provides clarity and certainty to both the employer and the employee at the outset of the employment relationship as to what the terms of employment are. In the absence of an employment contract, the employer and the employee may have very different recollections of what was agreed to at the outset. So a written contract removes the problems associated with faulty recollections and memories as to what the actual terms of the employment are. So this is an important thing to consider at the outset of the relationship. Now, what should be in an employment contract? On the screen, you'll see a number of matters that need to be raised with the contract and carefully considered. For example, will there be a probationary period? Usually, if there's a probationary period, it is a 3-month probationary period. What about bonuses? If there's a salary or an hourly rate of pay, what will be the bonuses and what will be the formula for these bonuses if there's going to be any bonus compensation? Another important issue is the employment going to be for a set period of time, or will it be for an indefinite period of time? So these are all very important, and they need to be carefully drafted because an employment contract is subject to employment standards laws. So you can't do a contract or have an employee sign a contract which may be legally enforceable to those who, contrary to the Employment Standards Act. So, for example, there's been changes, again, this year, adding a new job protective leave under the Employment Standards Act. This is an important addition to the Act. This is long-term illness leave. So this has been in effect since June of this year, and it provides an employee with at least 13 weeks of service to an unpaid leave for up to 27 weeks. You know, that's just over 6 months. If the employee has a serious medical condition. So this is new, and this impacts your sick leave policies, because if you have a sick leave policy that says, for instance, the employee is only entitled to 3 days per year of sick leave, you have to remember that this policy will be subject to the ESA long-term illness leave requirements. Now, also, when you're drafting employment contracts, you have to remember termination provisions. Again, the courts in Ontario have been very restrictive in terms of what termination provisions are enforceable and what are not enforceable. I've provided links to a couple of cases from our Ontario Court of Appeal, which held that the termination clauses in employment contracts were not enforceable. So that means in those cases, the employer was not able to rely on what was in the employment contract and the employee who was terminated was entitled to significantly greater compensation based on common law principles and not those minimum ESA standards, which provide a lot less of compensation to terminated employees. Another important issue to consider when you're hiring a person to fulfill a position is, will they be a remote worker, in-person worker, or some sort of hybrid basis? This has gained significant importance since the onset of the pandemic back in 2020. Usually, the default position was in-person work, but more and more positions are becoming remote. And you need to be aware that the employment contract needs to be clear on what will be the nature of the employment. So you need to check your employment location clauses before your next hire to make sure they align with what you want to do with that particular employee. I note that this is a particularly important issue in Ottawa these days, where I am, as federal government employees are being required to return to work after several years of many of them working solely on a remote basis. Also an issue to consider, if you're hiring an employee outside of the province of Ontario or even outside of Canada, you can't assume that the laws of Ontario will apply to the employment relationship. For example, if you're hiring an employee in the province of Quebec who is working remotely and residing in Quebec, the laws of that province will apply. So instead of the Ontario Employment Standards Act, you'll be dealing with the Quebec Civil Code and the Quebec laws relating to employment standards. And you also may be dealing with Quebec language laws. So if you're hiring an employee outside of Ontario, you need to modify or perhaps completely rewrite your employment contracts for the other jurisdiction. Now, there are some other legal requirements in the onboarding process that need to be carefully considered as well. There are training requirements that are often overlooked by employers, but it is important that they not be overlooked because they are mandatory legal requirements. For example, employees are required to provide employees training concerning harassment and violence in the workplace. As many of you know, since 2012 in Ontario, employers are required to maintain workplace harassment and workplace violence policies, and it is mandatory to train these employees on the contents of these policies and programs. I've provided a link to a summary of from the Ontario Ministry of Labour that provides very useful information on that. So in terms of potential liability risks, this training under the OHSA is very important, because if there is a workplace harassment claim made against the employer and there is an investigation, either an internal or often an external investigation, the first thing the investigator is going to want to ask for is what training has been provided to the employees under the OHSA, and they'll want to see your policies, and they'll want to see the proof of training has been completed. So don't forget this workplace harassment and violence training. There's also mandatory training for employees under the Accessibility for Ontarians with Disabilities Act and as it relates to the Human Rights Code for persons with disabilities. Again, this training needs to be done preferably during the first few days of employment. I mean, this may appear daunting to some small charities and not-for-profits. They may ask themselves, how can I get this training done? Do I need to hire an outside trainer and incur the expense of doing so? And no, that is not correct. The training is relatively straightforward. There are online modules that are readily available to employers, and we've provided 3 links there for your information. I mean, in my practice, what I've found is some charities and not-for-profits just don't know about these training requirements. So it's important for everyone listening here to know that these training requirements are mandatory, and you could face potential penalties under those statutes if you don't provide the training that is legally required. So, key takeaways from today. Review your employment practices to ensure compliance with the newest ESA requirements. Employment law statutes in Ontario and other provinces change quite frequently. So, as charities and not-for-profits, you have an obligation as the employer to make sure you keep up with those changes so you remain compliant. Don't assume what was sufficient 5 years ago or 10 years ago in terms of your employment practices is legally compliant today. Try to keep up as much as you can with changes in the laws. Now, secondly, employment contracts. Make sure you have a good bulletproof employment contract before the employee starts their job, because it reduces the risk of potential liabilities arising from faulty contracts. In particular, make sure your termination clauses are up to date and meet current ESA and common law standards. Finally, as employers, you need to make sure that everyone in your organization at the management level, in particular, and the board level, is aware of employment laws changing and keep up with your policies, your hiring processes, and your termination processes. So that brings me to the end of my presentation today. I hope you got some good information there, and thank you very much.
Well, thanks very much, Barry. I think a lot of people will appreciate today. It can be hard to be a charity. It can be doubly so hard to be a charity that's an employer, which most charities are. So there's a lot of pitfalls to navigate, as we've seen from Barry's presentation. So thanks very much, Barry, for walking everyone through that. Now we'd like to turn things over to 2 partners with the firm, Esther O and Sipa Albani. Esther O is a charity and not-for-profit law practitioner with our Orangeville office, and Sipa Albani is up in Ottawa, and she is our resident expert on all things intellectual property and copyright, and they're both going to be speaking on the exciting topic of rebranding. So over to you guys.
Okay, thank you very much, Ryan, and thanks everyone for being here. As Ryan mentioned, today Esther and I will walk you through the key steps involved in successfully branding your organization, and we'll focus on protecting your new name and your new brand. Esther will walk you through the corporate side, and then I'll discuss trademark use and protection. Okay, so let's start at the beginning. So before you begin a rebrand, the first and most important step is to choose a legally strong new name. For a charity, for a not-for-profit, or really any organization, your corporate name is more than just your label. It should reflect your mission and your values, but it also needs to be protectable. And when we say protectable, we mean both from the corporate and trademark perspective. So before you select your new name and march off to legal counsel and the marketing firm to start rebranding, it's important to grasp and understand what it actually means to have a strong name. So very simply put, a strong name is one that stands out, it's one that avoids confusion with others, and one that is available for registration, of course. It's also hugely important that the new name is distinctive, meaning that it's not descriptive of your services or too similar to existing names already out there. Getting this right from the start sets the stage for a smooth and successful rebrand. So over to Esther now to walk us through how to legally change your corporate name.
Thanks, Epal. From a corporate law perspective, the first step in the process of legally changing your corporate name is to check whether the name you want is available. This is done by ordering a preliminary nuance search, which will search a number of different government databases for names used by other organizations, similar or identical to your desired corporate name. A preliminary nuance does not reserve the corporate name, unlike a nuance name reservation, which I will explain a bit later. It's important to make sure that you check the correct database. If your not-for-profit is federal and governed under the Canada Not-for-Profit Corporations Act, then a preliminary nuance at the federal level, which searches databases across Canada, is required. If your not-for-profit is governed under the Ontario Not-for-Profit Corporations Act, then a preliminary nuance at the Ontario level, which only searches the databases in Ontario, is required. After you receive your preliminary nuance name search result, it's important to look through it and check for names which are identical or very similar to your desired name. If your desired name is confusingly similar to another existing name, your desired name will not likely be approved by the government as a corporate name. If there are elements in your desired name you really like, it may be possible to add one or two words that would help to distinguish your desired name from the other existing names. Now, for federal not-for-profits, there is the option of ordering a corporate name pre-approval from Corporations Canada to confirm whether or not they will approve your desired corporate name. That way you can know whether your name will be approved before you file the application for articles of amendment to change your corporate name, instead of having your articles rejected on the basis that the name is not approved. A nuance name reservation, which does reserve the name for 90 days, will need to be filed with the corporate name pre-approval request. This process is free, normally takes 1 or 2 business days to receive a response. Corporations Canada advises your name is not suitable on the basis that it's too similar to that of another corporation. It's possible to submit an explanation saying there won't be confusion in the public because the activities are different. We had one situation where our client was a registered charity providing food to those experiencing food insecurity, and there was a similarly named business doing completely different programs where Corporations Canada accepted this argument. But we had another situation where our client was applying to be a registered charity to provide low-cost housing, and there was an existing business involved with constructing homes. In this second case, Corporations Canada said the activities are too similar, so your charity client needs to change the name to make it more distinctive. The option of requesting a corporate name pre-approval is unfortunately not available for Ontario-based not-for-profits. Sometimes a not-for-profit might want to use a name that contains the name of a person where a charity wants to commemorate the work of an individual, or in other cases, a not-for-profit might want to change the name to one that is similar or identical to that of other not-for-profits. In both cases, written consent will be needed. Where the similarly named not-for-profit is in the same family of organizations, the parent organization normally has no problem providing written consent for the provincial affiliate, for example, to use an identical name. But if the not-for-profit with a similar name is a complete stranger, it's very unlikely that they would consent to your not-for-profit using a similar name. They might even want to take legal action to stop you from using a name that is similar to theirs. Where written consent is obtained, a copy of the signed form needs to be filed with the application for articles of amendment to change the corporate name. I will now let Sipal speak to you about the trademark searches that can be done.
So when choosing a new name, many organizations tend to believe that once a nuance report clears, they're safe to use that name. However, in reality, nuance is quite limited. It essentially only checks whether another has formally registered the same or similar name. A comprehensive trademark search, on the other hand, takes a much broader view. It examines not only the trademark register, but also unregistered use of the name on the internet, domain names, social media, basically to see whether anyone is already using a similar name that may cause confusion. So this is very important because in Canada, trademark rights come from first use, regardless if you have a registered corporate name or not. So this means that if a third party has used the same name as you, even without a corporate name registration or trademark registration, and you start using the name after them, they could effectively stop you from using your new name and sue you for trademark infringement or passing off. So as you can imagine, doing these clearance searches helps avoid disputes and ensures the name that you choose can be safely used for many years to come. Now back over to Esther to discuss the nuance name reservation.
Thanks, Sipal. Going back to the earlier steps I reviewed, if it appears your desired corporate name may be available, the next step is to formally reserve your desired corporate name by ordering a nuance name reservation if this was not already done. This will reserve your desired corporate name for 90 days from the date it was ordered. And during those 90 days, no one else can incorporate or apply for articles to change their corporate name using the name you reserved. So it's important to diarize reminders in your calendar so that you can monitor the 90-day deadline so that you can order a new nuance the next day after the previous nuance expires if it becomes necessary to do that. Unlike a trademark registration, a nuance name reservation does not provide ownership over the reserved corporate name. And where a not-for-profit has a corporate name it does not want other parties to use or misappropriate, whether that would be in the present or in the future after your not-for-profit has grown in size, the not-for-profit may consider seeking a trademark registration. A little later in the presentation, Sipal will be explaining the difference between a corporate name and a trademark registration. To legally change the not-for-profit's corporate name, the articles of amendment changing the name will need to be approved by the board and members of the not-for-profit at meetings duly called for that purpose, as Jackie also mentioned earlier in her presentation, then filed with the appropriate government authority for processing. After the articles of amendment have been issued, not-for-profits that are registered charities must provide a copy to Canada Revenue Agency to update their records. Where a not-for-profit has registrations in other provinces or countries, steps will need to be taken to update those registrations too to reflect the new corporate name. The articles should also be provided to the not-for-profit corporation's bank, insurance broker, accountant, lawyer, and other parties with whom the not-for-profit deals with in order to inform them of the name change. And if the not-for-profit owns land, the land registry system should also be updated to reflect the new name. In some cases, a not-for-profit may want to consider completing a business name registration for its former corporate name. If the not-for-profit is a charity, it's possible that a donor might have written a will many years ago naming the charity as a beneficiary, but by listing the former corporate name. If the will was not updated to reflect the new corporate name, having a business name registration can help to provide a legal connection between the not-for-profit and the former name for purposes of that estate gift, or if the charity receives checks written out to the former corporate name. The Business Names Act in Ontario states a corporation cannot carry on business or identify itself to the public in Ontario using a name other than its corporate name, i.e., the full legal name written in your Articles of Amendment, unless a business name registration is done, and there is separate legislation in each province for this. Sometimes a not-for-profit might have a distinctive program, or larger not-for-profits like universities or hospitals might have different names given to the wing of a building or a campus to recognize a donor. These are other examples where a business name registration may be required. Sipal, back to you for comments from a trademarks perspective.
Thanks, Esther. Now that you all know how to legally change your corporate name, as Esther mentioned, I'm going to walk you through how to protect that name and properly use it. So the slide you see in front of you right now explains the key differences between a corporate name and a trademark, which is important for organizations to understand when choosing and protecting their names. So as a reminder, a corporate name is the official legal name of your organization. It identifies the entity that provides the services, carries out the missions, and all of your legal documentation must, of course, have your legal name on it. However, trademark is different. A trademark is used to identify the source of your goods and services to the public and to distinguish them from others in the marketplace. Essentially, it's your brand. Sometimes, and probably often with charities and not-for-profits, the same name can function as both a corporate name and a trademark, but only if it's used correctly. Trademark rights can accrue through use or through formal registration under the Trademarks Act. Just because you register a corporate name, as Esther mentioned, does not mean that you will automatically have exclusive rights to the name. Without a trademark registration, you may be leaving your new name vulnerable to attack. Therefore, to truly protect this new name, a trademark registration is essential. Okay, so this slide is quite important because in Canada, rights in a new name only come from actually using that name with your goods and services. So simply filing an application or registering a corporate name does not give you enforceable rights. So often you pick a name, you do searches, you get approvals, and you register it. And then you spend, maybe a year or two designing and planning for the new rebrand rollout. Meanwhile, what can happen is someone else may start using the same or similar name and build prior rights in that new name, and they could therefore stop you from using that new name, which is obviously quite devastating for organizations. So to avoid this, you'll want to work with a trademark lawyer early on to plan for limited use and lock in your rights before your big rebranding launch. So to protect a new name, trademark applications should be filed before the public launch. This helps secure priority and reduces the risk of others claiming rights first. It's important to consider separate applications for different elements, like your corporate name, of course, but also any slogans and design marks you may have, so that you're covering all aspects of your brand. Coordinating the filing dates with marketing and public announcements ensures that protection is in place before you go live. And of course, if your organization operates or fundraises or offers services internationally, you'll want to consider foreign trademark filings. Okay, so hopefully everyone is still awake and I haven't lost you, but on this snazzy slide in front of you, you'll see a summary of the differences between unregistered trademarks and registered trademarks. And I'll let you review that on your own time. But one key point that I do want to note is that if you're relying on unregistered trademark rights, your rights are precluded to the geographic area in which you offer your services and that you have a reputation in. So what does that mean? So if you are operating and offering services in Toronto, for example, you cannot stop someone from using the exact same name in Alberta, for example. However, with a trademark registration, you have ownership and protection nationwide, regardless of where you use it. So that is huge. When moving to a new brand, it's important to keep using your existing trademarks until the new one is firmly established. So often organizations will use language such as formerly known as to preserve the goodwill and keep donor recognition intact. You also want to keep using your old marks just enough to avoid losing them. It's a bit like keeping a plant alive. You need to water these trademarks occasionally so they do not wither away. And your trademark agent will be able to help you do this strategically. Finally, as Esther mentioned, filing business names for the legacy brand also adds another layer of protection. So once a new brand is launched, consistent use becomes absolutely critical to building and maintaining your trademark rights. This starts with very practical steps such as securing your domain name, social media handles, and then of course updating your stationery, signage, and all of your digital assets so that your new identity is unified. Equally important is, of course, internal education. So staff, partners, people you work with, they should understand how the trademark should be used and how it should not be used. Often we find that a brand usage policy or brand guide helps organizations set these standards. And perhaps most importantly is we need to remember that trademark rights can be lost quite easily if they're not actually controlled, enforced, and monitored. So many of our clients are actually quite surprised to learn that simply registering your corporate name or even registering trademark is not enough. Ongoing vigilance is essential to protect your name. So this means things like stopping unauthorized use of your new name, having license agreements in place for any authorized users, and also ensuring adequate trademark protections are built into your agreements, such as your gift agreements, your sponsorship agreements, and other contracts. And with that, I'll turn it over to Esther, who will summarize some of the key takeaways from today's session.
Great. Thanks very much, Sipal. That was such a helpful explanation. So in the interest of time, I'll just briefly mention that the key takeaways are summarized on the last two slides and they can be read at a later time. But in a nutshell, it's important to do your homework before choosing a new brand and corporate name. The proper steps should be taken to change your name and register trademarks. And follow-up matters listed in the slides should also be reviewed and addressed afterwards. That concludes our presentation.
Well, great. Thank you, Sipal. Thank you, Esther. It really is an important area. So many charities and not-for-profits are looking at the issue of rebranding, and so thank you for giving us that oversight. Now we're going to move over to our first fireside chat, and in that regard, delighted to introduce Bruce McDonald. Bruce McDonald has spoken before at our annual event. Bruce, who you may be aware, is the president and CEO of Imagine Canada. Imagine Canada really is the premier umbrella organization for charities and not-for-profits in Canada. And prior to that, he was the CEO of Big Brothers Big Sisters of Canada. And Bruce, we're really happy to see you here. We're looking for there we go. We've got that fire for you, Bruce.
Lovely.
In order to have this chat together, and you know, Bruce, I think of you as being kind of like the insider report to help us to understand the sort of the lay of the land. So thank you for being part of the session today.
Oh, my pleasure. Thanks for the invitation. Really looking forward to the conversation.
Great. Okay, so this is all about the inside scoop. It's okay, like pretend no one else is listening. This is just like the insider report for the ZERS and the PC President's Choice. So first of all, Bruce, you know, it's been a couple of weeks since Prime Minister Carney and the Liberal government tabled its fall budget. The budget proposed, you know, both significant investment spending and major cuts to the federal civil service. So from your perspective, your insider perspective, what did it mean for charities and nonprofits?
Yeah, it's a great question, Terry. I mean, it's for us, we kind of view this as a little bit of a mixed bag in the sense, it's funny. It seems that that's an expression we use with many federal budgets these days. But, if we really dissect it, there was some significant investments in areas where our sector participates, things like the National School Food Program, women and gender equity also, received some significant support, continued support for the Canada Summer Jobs Program, Youth Employment and Skills Strategy, Canadian Music Fund. As well, there was supported investments in the disability tax credit, New Horizons for seniors. These are all areas where charities and nonprofits play a role. And what was also great was to see the introduction of automatic tax filing for low-income Canadians. So all of that's really good, but all of that is program funding. And it's interesting. In the language of the budget, the government, in fact, used the term, a strong social safety net. It's funny, we haven't heard that term in a while in these kinds of things. So for us, though, what's missing is a recognition and an understanding, and then actually support, that the strong safety net actually relies on the strength of the organizations that deliver the programs. So simply investing in programs is good, and it will help people in communities. But in some cases, it actually puts strain on the very organizations who will be asked to run them. Because there have been, and this is part of the whole fair funding for nonprofits work that's being done by ourselves and others, there's programs that come out that don't allow organizations to take really any or even a fair amount of revenue for the operations, which are critically important, as we know, to delivering quality programs. So, it was heartening to see that areas of the sector were invested in, but I think we're still missing the big picture, which is in a long-term sustainable way, those organizations that are delivering the programs need to be supported.
Yeah, when we're looking at trying to build up and undergird the structure of Canada, the charitable and not-for-profit sector is huge, absolutely huge. And there was not a lot of focus on that essential part of our Canadian society. So I would agree with it. It wasn't all that we were hoping to see, but it's something. So well, thanks for that, Bruce. So a bit of a follow-up question relating to working with a minority parliament. And we've been here before over the years. So what are you seeing as it relates to interest and activities from both the government and the opposition sides of the House on issues affecting the nonprofit and charitable sector?
Yeah. So it's an interesting time in a sense, because while it is a minority parliament, it's the largest minority parliament in the history of federal governments. So there is a presumption that this one may last a little bit longer than the usual. So most federal minority governments last just under 2 years. That's the average. Right now, I think the prevailing thinking is somewhere between 2 and 3 years, but we'll see. And I would say, I'm going to kind of dissect the answer a little bit as we think about the government side. I would say, as it relates to interest in the sector writ large, it has been challenging to get the government's attention. They've had almost a laser-like focus on tariffs, the economy, sovereignty, and the actions of our neighbors south of the border, which have a huge effect here in Canada. And so getting the attention of the government, even when we're talking about the contribution of the sector through economic terms, has been challenging. I think the good news was some of that clearly got through from parts of the sector that were invested in the government. As it relates to the opposition, it's interesting. I mean, clearly, the Conservatives have a lot going on right now internally, but as I always say, there's some great MPs who are always interested in meeting and talking about issues of the sector. The NDP, it's an interesting time right now, very internally focused in terms of not having a leader, not having official party status, because the other part is they're not on committees, which leads to the next point. The Bloc Québécois has more influence than it has in a while, particularly at the committee level. because you have almost an even split between Liberals and Conservatives on each of the parliamentary committees. And it looks like in some cases, the tie-breaking vote may fall to the Bloc. So it's important for us to be engaging. And in fact, on our most recent Hill Day, the most active group that had the most meetings was our 100% French language group that was in meeting with organizations. But the other part I would say is that we've got more engagement with senators. So there have been a number of appointments over the last year of senators who actually come from the charitable and nonprofit sector. And in fact, just a few weeks ago, our colleagues at Philanthropic Foundations Canada hosted a roundtable for senators and MPs. And it was great to get some of these new senators in the room to really see what contribution they can make. So, you know, I think what we've been hearing sort of loud and clear is that for our sector, we should be louder and bolder. Because we've got more noise to cut through right now in terms of all of these interests around the economy. We also, as it relates to the government side, need to clearly show the link between the 7 priorities listed in their one mandate letter and the work of the sector, at least in the short term.
Okay. So, Bruce, you know, a number of organizations attending today, they've got issues, they've got agendas, they want to move forward. They don't have a big budget. They don't have the ability to do, you know, government relations themselves. Is there a role here for Imagine Canada to be able to help facilitate advocacy on behalf of smaller organizations if they've got issues that they want to bring to the government's attention? Is that something that Imagine Canada can help with?
It's going to be a decidedly middle of the road answer. It's a yes and no answer. So, you know, our mandate in our work is not to advance the interests of particular organizations or particular subsectors. What we can do, however, is we do this all the time. We can help work with organizations to have conversations with them about the tactics and strategies that might work well. Because I would say that regardless of the mission or cause, the key part of this is getting to members of parliament in their communities. When they go back to Ottawa and sit in caucus and raise issues, and that is heard time and time again, that's when we start to see real change.
Right, right. Yeah, just to concur, you know, some issues in the past year where there's been some concerns that that we've seen as lawyers, that others have seen as well. The best way to be able to impact the government is to get out with articles and get out with communication, with emails, with petitions, so that the politicians know that we're there and
absolutely
hopefully they're going to listen to us. So.
Yeah.
Well, that's great. So the elephant in the room, Bruce, you know, one of the dominant issues we've had to deal with has been the global disruption emanating from our friends south of the border. So what are some of the challenges and then the opportunities that the kind of the upending of the global economic order presents for our sector, at least from your perspective?
Yeah. So I think it was Winston Churchill who said, like, never let a good crisis go to waste. And I think that's probably the mindset that our sector needs to have. You know, it's interesting. I have the real privilege and pleasure of talking with 3 to 5 leaders of organizations a week. We just set up 30-minute calls and have conversations about what's happening in their world, in their communities. And I would say if there was one word I would use to sum up the mood, it's apprehension. There is a nervousness about the state of our country, the state of our economy. And of course, we know that there is this inverse relationship, or this interesting relationship between the health and well-being of the economy and for charities and nonprofits. When the economy is disrupted, supply or revenue drops, but as well, demand rises. So there's this squeeze for the services provided by organizations. And of course, as we think about the challenges, you know, the report that PwC came out with in the spring talked about the fact that based on the tariff analysis in the springtime, they were estimating a drop of about $100 million in giving in 2026 compared to pre-tariff levels. Well, that's not an insignificant amount in our sector. And I think the other thing that people are really keeping their eyeball on is the renegotiation of the current free trade agreement. So while we do have sectors of the economy that are getting squeezed and hurt, it's important to remember that 85% of the goods and services that flow between Canada and the United States are currently protected under what's called now CUSMA. That renegotiation will be central to what we're looking at in 2026. It will have a ripple effect on the economy. I think most experts are thinking it's unlikely to be a free trade agreement, hopefully a low tariff agreement, but any tariffs will have implications for Canadian companies. So I think for the leaders of charities and nonprofits, the opportunity then lies within to say, well, is this now a moment of conversation about real change? How can we be thinking about our business models, the way we use technology, and are there innovative practices that will help us power through and kind of lean into this disruption to be able to say, doing nothing is actually going backwards if everything else around us is changing. So I think really for me, as I'm talking with the leaders of organizations, and I'm hearing some of these, is that they're really looking to say, if this is a prolonged period of change, because I think we're also seeing kind of an unpredictability in the conversations, setting up our organizations and ourselves for a future that will look different is important so that we can still be there for our communities.
Right. So what are you saying, Bruce, with regards to the opportunities that are being spoken about in order to respond to the upending of the global order? What, both in Canada and internationally, are you seeing some opportunities that are being discussed that some
Absolutely.
of our attendees might learn from?
Yeah, we're seeing organizations who are saying, you even take the kind of the international development space where not just USAID, but many other countries reduced aid. The way of delivering service that Canadian organizations are participating in, it's going to have to change. We hear of organizations saying, well, maybe it is time to find comrades in arms, others who are delivering similar services, and say, let's have a business model conversation. That could be everything from robust partnerships as far as mergers. And I think the other thing we're hearing about is, if it looks like there's going to be this sort of prolonged period of disruption, maybe a flattening of revenues coming from governments and corporations and those kinds of things, how can we use technology to drive impactful programs and be more efficient? And those, I would say, are kind of the three areas that we're hearing the most of right now.
Well, there are some tools that have been made available to help reduce the administrative challenges of charities. I mean, particularly internationally, with regards to the introduction of the qualifying disbursement regime back a few years ago. We've talked about that. It still has complexities associated with it, but it does mean that charities are able to work with non-charities in a way that they weren't able to before, and so that's sort of the advantage of a regulatory change, which now is becoming a helpful tool for charities to be more efficient in what they do.
Exactly. And I think not just more efficient, but also drive to the kind of impact they want to have in communities where maybe before the very organizations they wanted to work with, it was just too hard to do so.
Yeah. Now, on the comparison between south of the border and Canada, Bruce, we like to think we're different, right? But are we? When I'm part of the American Bar Association, I go down to meetings, and there's a lot of concern by charity lawyers there about the ability of organizations there to be able to do their work, frankly. A lot of targeting of organizations. Are we free of that, Bruce, or are there some risks up here in Canada as well that we too could be subject to some of those concerns?
Yeah, I'd say there very much is right now, to a lesser degree, thankfully. We call it the politicization of charities. And I don't think this is anything new. It's not aligned to a particular party or ideology. But I'd say that if we were looking for a theme or a pattern, that as politicians are advancing their interests, at times we're seeing them cast a wider net. And now charities and nonprofits are being caught up in that net. We're by law a nonpartisan sector, so it makes it harder to engage in a way that continues to be neutral. But I think what we're hearing from organizations is the greater concern about that, greater concern around polarization of the dialogue, meaning that more organizations are saying to us, we are having things said to us and about us online, or actually to our staff and volunteers. What we want is a respectful discourse around the way communities should function in this country. So we're not immune to it. I think it's not this at the same degree or scale. And what we're hoping to be able to do is ensure that we manage that so that organizations can contribute from an advocacy perspective to advocate for their communities and have it done so in a healthy way.
Yeah, we may not all agree all the time, but at least we can talk about it.
Yes.
I think that's the key issue. Canadians have the ability to be able to discuss issues. We don't always have to agree, but we can have a civil dialogue back and forth and keep focused on the purpose, keep focused on the social good that can be achieved. So, well, thanks for that, Bruce. Imagine Canada, because it's a really important organization. You're kind of uniquely situated in observing key trends that are affecting the charity and nonprofit sector. So, are there some that you're keeping your eyes on that on the insider report sort of theme that we have here today that you can share with the folks attending?
Well, yes, and in keeping with the kind of insider report, maybe just going to focus on two areas on some data that actually is not out publicly yet.
Okay.
So, it's interesting. We've been spending some time really engaging with Canadians to understand their perceptions of the value of the services provided by charities and nonprofits in their communities. And, part of it is thinking about what does the future of the sector look like, also understanding that the individuals who have supported the sector almost since the end of the Second World War, we are seeing a changing of the guard driven by demographics and age. And I would say, though, the nice part is there's some really good news in there. So we did focus groups across the country in the summer, and then in September, we did some consumer polling. And, 2 in 3 Canadians understand and believe that the need for services in their communities has increased. So they're kind of getting the fact that the sector is being squeezed. For me, there was a couple of standout findings, though. One was that 8 in 10, so 80% of folks who were surveyed, said that the services in their communities were essential. Not nice to have, not good to have, but essential. So fundamentally important to the way their communities are. We actually gave folks 17 cost centers and invited them to say, well, what's fair and reasonable for organizations to spend money on? 79% of folks saying that the number one thing that organizations should be spending money on is data protection. They're providing private health information for their families or donor information. They expect that organizations are keeping it safe, and they're prepared to say part of my investment can go to that. But the one that was really interesting, Terry, was that we asked people if they knew someone who had benefited from the services of a charity or nonprofit. The number that came back was 41%. That was stunning because the actual number is 100%. So what it tells us is that we have some work to do in helping organizations and communities understand that the services that people are accessing are in fact being delivered by charities and nonprofits. As always, I'm kind of an optimist. To me, that's room for growth. That's room to expand the tent so that more people kind of get it, that literacy program that their child went to in the local public library was delivered by a charity and not necessarily the municipality, those kinds of things. The one other one I'll mention just in terms of trends, and it's kind of one of the hotter topics in the sector, is around the use of artificial intelligence. And we did a survey, and the findings will be coming out early in the new year, but I'll give you a little bit of a sneak peek, is that, we asked about the usage, and about 80% of organizations responded that they're using AI in some way, most, though, for fewer than 3 organizational activities. So they're still kind of dabbling and testing the waters. The one that was interesting to us, though, was about a third of organizations say they have policies in place to guide their use of AI, but 2/3 don't and are not currently working on policies. And so from a risk mitigation perspective, we think it's important to not treat AI as the Wild West so that people aren't putting proprietary information or data that should be protected unknowingly into AI engines. So there'd be more coming out about that in the new year, and the new AI nonprofit AI Impact Hub just launched with all the resources to help organizations be able to protect themselves and understand. But I think this is a key one to lean into a little bit so that our sector and the organizations don't inadvertently expose themselves.
Well, a good comment and good lead into one of our sessions after the coffee break on AI with regards to charities, not-for-profits, but with a focus on policy. So that'll be a good session. So we have about 2 minutes left. I'm going to give you a choice. You can either, Bruce, talk about the advisory committee of the charitable sector, or if you want to talk about, we're going to the holiday season. What do you think are things that are coming up next year for the charity and not-for-profit sector? So over to you, Bruce. Which one would you like?
Well, you're a game show host here, Terry. So I'm going to go with door number 2 and talk about what's coming up.
Okay.
So for us, just very quickly, a few things. Preparations for the 2027 review of the disbursement quota. Really trying to understand in 2026, is the data telling us the answer to 2 questions? Did more money flow in as a result of increasing the disbursement quota? And I think the companion piece is, did money flow differently? Going back to your comment about qualifying disbursements, are we seeing a change of the patterns? I think that, as I mentioned earlier, looking at the state of the economy and how that's going to affect organizations, not just in the early parts of 2026, but throughout the year, will be really important. And I think the other thing that is just sort of underlying, at least for our work, and it'll be interesting to engage with organizations, is, as you talked about earlier, we are in a minority parliament. For us, it'll be thinking about how are we actually preparing to ensure that the sector is deeply embedded in the platforms of the parties heading into the next election, whenever that is. But for most organizations heading into 2026, it is understanding how the services that they have provided for a long time can be continued, and what does the sustainable future look like?
That's great, Bruce. And thank you for the reference to the disbursement quota, because that's a good lead in to Teresa Mann's going to be talking about the disbursement quota right afterwards. So we're prescient with regard to our discussion. Bruce, thank you for the insider report. We appreciate it. We know you're busy today and taking the time out to be with us. Always a pleasure to have you, and great insight. And we promise not to tell anyone. This is just between yourselves.
Perfect. Well, that's okay. You can tease people so that they'll read it when it comes out. But thanks for the opportunity. Sorry about the technical glitch, and I'm glad we were able to get back on in just a minute or so.
All good. All good. Thank you very much, Bruce.
Good luck with the rest of the day.
Thank you. So now we're going to take a 15-minute break. 10 minutes if you want to come back at 11:05 for fantastic jokes. But you don't have to. You can be away for 15 minutes if you wish. So 11:05 back for jokes, and then the program starts back at 11:10. Thanks very much, and have a good break for a few minutes.
All right. Well, we hope you've enjoyed a bit of a break, but for those of you that have rushed back, we know that you're back for the most important part of the show for you. And so we're going to turn it over to Terry for some of Terry's ever popular dad jokes before we begin after the break.
Well, they're not actually dad jokes, right? They're just they're quality jokes, but they are. And I want everyone to know that they've been carefully curated over the past year, choosing, excluding. Some of them actually I did myself. I won't tell you the ones, but some of them in there are brand new. So here we go. No Rotten Tomatoes. Why don't they play poker in the jungle? Too many cheetahs. Okay, and by the Ryan, are you on as well? Have I got you on? Because you're going to be my audience.
That's it.
Oh, okay. No, actually, to be fair to you, Ryan, you can turn Ryan off, because I wouldn't. Although, would you like to stay on and be part of the audience, Ryan?
I'll stay, Terry. I think it's good to always have a reaction.
You stay. That's great. Okay, remember to laugh as I go through it. Okay, why did the PowerPoint presentation cross the road to get to the other slide? What did the grape say when the buffalo stood on it? Nothing. It just let out a little whine. Why isn't Dracula married? Because he's a real pain in the neck. What happened when a frog's car breaks down? It gets, you have to think about it, it gets towed. Okay. That's a good one. What did the janitor say when he jumped out of the closet? Supplies. When does a joke become a dad joke? When it becomes apparent. When it becomes apparent. Ryan, you're a father, so you understand that.
I get it.
Okay. How come teddy bears refuse to snack? They're always stuffed. Okay. What do you call a can opener that doesn't work? A can't opener. A can't. Okay. What do you call a toothless grizzly? A gummy bear. Why was the scarecrow awarded the Nobel Prize? Because he was outstanding in his field. and here's mine. This is a perfectly new curated joke. What do you call a school fundraiser of tying shoelaces at the playground? What do you call a school fundraiser of tying shoelaces at the playground? A not-for-profit? I liked it. Okay. Why don't IT specialists like nature? Because there are too many bugs. What did the horse say after it fell over? Help, I'm falling and I can't giddy up. Why do seagulls fly over the sea? Because if they flew over the bay, they would be bagels. Okay, I've got 2 minutes left, so I'm gonna move down to someone's ear. What is your small toe for? To make sure your furniture is in the right place. And what are spiders really good at? Surfing the web. I didn't write that one. Okay, some lawyer's jokes. We got to get some in here. Why did the lawyer make coffee? There was sufficient grounds. What do lawyers wear to work? Lawsuits. What did the judge say when the skunk walked into the courtroom? Odor in the court. Okay. 8 vowels, 11 consonants, and an exclamation mark and a comma appeared in court today. They are due to be sentenced next week. Did you hear about the new sushi bar that caters exclusively to lawyers? It's called Sosumi. Okay, I've got two sports jokes here. Why are baseball games at night? The bats sleep during the day. And then to end off with a couple of Maple Leaf jokes, what do the Toronto Maple Leafs and the Titanic have in common? They both look good until they hit the ice. And my final one is, why is the Hockey Hall of Fame in Toronto so Leaf fans can see the Stanley Cup up front more often than once a century? Okay, thank you very much, Ron. You were a great audience. So now we're going to go on to something more substantive, more helpful. Teresa Mann, partner with the firm for many, many years, 25 years, expert in charity law, is going to be talking about the disbursement quota, what charities need to know to ensure compliance. So over to you, Teresa.
Thank you, Terry, for reminding me that I've been around for a very long time. I feel like I'm a fixture. And that leads us to talk about disbursement quota this morning. So we're after a coffee break. Hopefully you're all waking up by Terry's wonderful jokes. And so what I'm going to do is we'll talk about disbursement quota, what it means, and we'll do some math together. Okay, that's good. So if you're around when Terry talked about all those wonderful jokes, there's a lot of what. So I'm going to start the disbursement quota on some basic questions. What, why, where, And how? What is disbursement quota? It is, in a very simple term, the minimum amount the charity would need to spend on charitable programs or qualifying disbursements from money that is set aside, not used for its programs or administration. And why do we have a disbursement quota? The rationale is to ensure that there's some minimum amount that charity spent on programs or qualifying disbursements rather than no disbursements. And where do we find the rules? Income Tax Act. Where else? And how? So it involves a formula and some math that we'll talk about in the next few slides. The disbursement quota, which is the minimum amount that would need to be spent, applies to investment assets that are set aside that are not being used directly in charitable activities or administration of the charity. So we'll talk about that in a bit more. So we talk about what, where, how, and where. And then what's missing is when. When is now. So this is a really brief history of the disbursement quota. I've been around with Carters for a very long time, and so is disbursement quota rules. It went all the way back, started in the 70s. Then it went through some reforms, some major ones. In 2004, the legislation made the rules extremely complicated. And then the sector complained because it's so complicated, nobody understood. And then there's another reform in 2010 that they simplified the rules. So there's another major reform. And then in 2021, 22, there's talk that they need to increase the disbursement quota to 5%. And then that became law in December in 2022 in June because of the budget. And then they proposed that there will be some minor changes, amendments to how the exclusions of what would go into counting towards disbursement quota. And that change is still being proposed. Budget 2025, there's a mention that they intend to move forward. So we'll see. So this is how complicated the disbursement quota is in 2005. And I'm so glad that it is over. And this is how it got simplified in 2010. And since 2010, the basic structure of the disbursement quota calculation remains the same. And now, if you are asleep so far, wake up, open your eyes, look at this slide. This is one of the key slides of the disbursement quota. If you forget everything that I talked about today, that's okay. I will not be hurt. I'll forgive you. But remember this slide. The disbursement quota applies to the two, what I call them, exemption thresholds. So for charitable organizations, if it has property set aside, not used in charitable programs or administration that is below $100,000, then they don't need to worry about this disbursement quota. It doesn't apply. For foundations, the exemption threshold is $25,000. So for charitable organizations or foundations that have assets set aside over this threshold, then they will need to calculate the disbursement quota. The disbursement quota, there are two rates. One is 2.5% for asset below $1 million, and then 5% for property above $1 million. So this is basically what that is about. And then, so a bit of a calculation. Let's do some math. So how do I find out how much the disbursement obligation is? Because there are two sides to the formula. We first need to calculate how much do I need to spend. So we call it disbursement DQ obligation. And then in a minute, we'll talk about what would go toward meeting the DQ obligation. So we'll talk about that in a minute. So first of all, we calculate how much do I need to spend? How much is the 3.5 and the 5%? So first of all, we need to calculate and find out what properties are included. You need to find I call it the asset base. The property included are properties that are not used directly in the charity's charitable programming or administration. And examples it could be cash set aside in GICs, investments, properties that are not used by the charity, put aside as a rental property, something like that. And then, so you gather, that's the property that you need to look at. Then we look at the time frame. There's a 24-month time frame that we need to look at. For example, if we are trying to calculate what is my disbursement quota for 2025 for this year, then we look at the 24-month time frame for the 24 months before 2025. So we look at January 1st, 2023 until December 31, 2024. That's the time frame that you need to look at. And then within the time frame of the 24 months, because you have the asset over the 24 months period, so what is the number that I used to calculate, apply the 3.5? That's where you need to calculate an average value of the 24 months. The income tax regulations says that you have a choice. You can divide the 24-month period into 8 periods, 4 periods, 2 periods, and then you take that number and then you do the average. So we'll give an example of how that averaging would work. But once the period is chosen by the charity at the outset, it cannot be changed. Future changes to the number of period used to calculate the DQ will need CRA approval. So here's an example. So for example, if we are looking at, we want to calculate the DQ obligation for the current fiscal year, January 1st to December 31st, 2025. So the 24-month period are the box in yellow. We look at January 1st, 2023 until December 31st, 2024. So that's a 24-month period to look at. Then how do I calculate the average value? So you have a choice. If you choose 2 periods, so that means you take the fair market value on an annual basis. At the end of 2023 and at the end of 2024, you average the 2 value, and that's the value that you need to apply the 3.5 or 5% DQ percentage. If you choose 4 period, that means you want to average it out on a semi-annual basis. Or if you choose 8 periods, that means you want to use the averaging on a quarterly basis. So which one is the best choice? 2 periods, 4 periods, 8 periods? It really depends on the nature of the asset. If the value doesn't go up and down very often, then maybe you can choose 2. But if it is investment in some mutual funds and you expect that the value may fluctuate quite a bit, then maybe 4 period might be a bit more suitable. Now we've done the calculating the DQ obligation. We know how much we need to spend to meet the DQ. Then we now need to calculate what can I spend on to meet the DQ. So with meeting the DQ obligation, we call it DQable. But I talk to a client when they're worried about whether this expenditure would meet the DQ or whether that expenditure would meet the DQ, we come up with a term, DQable. So what is DQable is included, will be disbursements spent on charitable activities, or gift made to qualified donors as a type of qualified disbursements, or grants made to non-QDs as another type of qualifying disbursements. Certain expenses are not included when meeting the DQ. For example, Right now, income tax excess expenditures on administration and management expenses are not included. Things like your insurance premium or the expenses that you use to run your AGM. So those are administrative, so that those expenses cannot be used to meet the DQ obligation. There's proposed changes to also exclude fundraising expenses. That is not law yet, so we'll see. Because of how qualified disbursements is defined, it includes disbursement by way of making resources available. So we don't know how making resources available means as part of grant to grantee. So that's a big question mark. We don't know how that would be included or excluded when calculating what is DQable. Something also important to understand is meeting a DQ obligation is calculated on a global basis, not on a fund-by-fund basis. What it means is, for example, if a charity, for example, it has 2 million in its bank account in total, and it has 500,000 in its daily operating account. It has 1.5 set aside in some GICs, mutual funds. So the 1.5 million would be part of the asset base. So you calculate the DQ obligation, the 3.5%, the 5% based on the 1.5 million set aside. So if you do the math right now, applying the 3.5 to the first 1 million, 5% to the remaining 500,000, the DQ obligation is 60,000. That's the DQ obligation. So the global calculation means the charity can spend 60,000 from the 500,000 set aside in its operating bank account. It doesn't need to spend the 60,000 from the 1.5 being invested. So that means global calculation. So very quickly, a couple more concepts. If a charity spends too much on charitable programming or gift to QDs or grants to non-QDs in a year over its DQ obligation, so it has a DQ excess, you can apply the DQ excess for the next 5 years if it doesn't spend enough, or you can apply to a shortfall if it did not spend enough in the previous year. Similarly, if the charity doesn't spend enough in the current year, then you can look to whether it has any excess in the past 5 years, or you can spend enough in the following 1 year. The next few slides will talk about reporting DQ in the T3010. I've taken some screenshots from the current version of the T3010. CRA updates the T3010 from time to time. The current version is version 24. That's the version that charities will have to start filling out, inserting more information about its DQ in the T3010. So I'm not going to go through this line by line. You can look at it in a bit more detail. But something that you do want to keep in mind is there's a general tool line in the T3010 that requires the charity to calculate the asset of the 24 months before the current fiscal year for purpose of calculating the DQ obligations for the current year, and also to calculate the asset of another 24 months in order to project how to calculate the DQ obligation for the following year for planning purposes. Then there's a question, 17, that excludes exemption for whether the charity, a foundation has less than $100,000, or a charity foundation less than $25,000, or charity less than $100,000. If you answer yes, then it doesn't need to calculate the detailed calculation in Schedule 8. If the DQ obligation applies, then you need to fill out Schedule 8 in a bit more detail. So the screenshots are there with detailed instructions. If a charity has problem meeting its DQ obligation, it can apply to CRA to reduce the DQ obligation, but it is only granted in unusual circumstances after the charity has exhausted all other revenue and has reported in the T3010 that there's a shortfall, it has a problem, then they can apply for CRA for relief. There are a couple of anti-avoidance rules that applies to gift between arm's length charities and non-arm's length charities. The rules are there, and it's just not too complicated to understand, so we'll quickly flick through them. You can take a look at that tonight when you cannot sleep. You're wondering about DQ, so there are a few slides that talk about transfer between charities that are arm's length and non-arm's length.
1,000.
And then lastly, because the DQ was increased from 3.5 to 5% in 2022, so there are some challenges for charities to meet the DQ. For example, if it has funds set aside in like endowments, what if the donor has imposed restrictions on disbursements, or what if the investments doesn't generate sufficient return to meet the 5%, or what if the charity doesn't have enough money in its general funds not invested to meet the DQ without dipping into the actual investments. So these are all challenges. And I also echo what Bruce McDonald had talked about in the fireside chat. By increasing 3.5 to 5%, the objective is to make sure that there's more expenditure flowing into the sector. And next year and 2027 would be the first couple of years when we actually see whether there's actually more expenditures flowing into the sector as a result of increasing the disbursements from a percentage from 3.5 to 5%. So for those that want to read materials, have some resources listed there, and also the links on our website, then you can take a look at that, and then we can talk some more next year.
Well, great. Thanks very much, Teresa. The disbursement quota is no joke, but thank you for taking a Byzantine topic and making it entertaining and digestible for everyone. Thanks very much. Now I'm going to move things over to two associates with our firm, Martin Wismith and Cameron Axford, who both practice here in our Orangeville office, and they wear many hats with practices ranging from corporate law, employment, privacy, and helping with all the research and the many publications that the firm puts out. And they're going to be continuing, as Barry mentioned earlier, to speak on the very important topic of AI. Over to you guys.
Thank you for the introduction, Ryan. We're excited today to talk about a topic that's rapidly changing how organizations work, artificial intelligence. Today's goal isn't to turn anybody into a tech expert. It's to show why every charity and not-for-profit should have an AI policy, one that helps you manage risk, protect data, and still take advantage of AI's benefits responsibly.
Artificial intelligence is, to put it simply, really just a system that performs tasks that normally would have required human reasoning. Things like summarizing or drafting or translating. So you don't need to be a tech wizard to benefit from it, but many of you are already using AI without realizing it. For example, Microsoft Copilot is a popular platform and can suggest email replies in Outlook, or rewriting sentences in Microsoft Word, or your security software might be catching odd activity with the assistance of AI. The key point is that AI can help you work smarter, but accountability for what it does always stays with you and your organization. So that raises the question, if we're already using AI every day, why is now the right time to start thinking about a policy?
Well, Martin, that's a very good question. And just for the audience's knowledge, we're skipping over some slides in the interest of time, but they will be available later. So AI isn't just for high-tech companies. As you mentioned, Martin, it's built into the tools we're using every day now. Microsoft, Google, even our email security systems. For charities and not-for-profits, AI can help you draft newsletters, summarize reports, flag compliance issues. There's really an endless list of possibilities. But the real question isn't if AI is going to impact your organization, it's how you're going to manage it. Today's goal is to help you take a governance approach, to use AI safely, thoughtfully, and in a way that builds trust with your donors, staff, volunteers, members, board, really all your stakeholders. So none of this happens in a vacuum. There's a legal and regulatory backdrop we can't ignore. So where does that leave us right now?
In Canada, the federal AI framework is still in development. There's no AI law in force yet, but privacy laws, contract laws, and sector-specific rules already apply. So this past September, the federal government launched what it calls the AI Strategy Task Force, and that is a consultation with stakeholders and experts in AI, including charities and not-for-profits. So regulation is coming at some point. We're just not exactly sure when. Could be sooner or later. Courts and regulators are already signaling that organizations are responsible for how they use AI, even while the potential liability for developers of these AI platforms remains an open question. And globally, we're seeing standards like the European Union's Artificial Intelligence Act, the standards organization ISO 42001, and these both emphasize risk management, transparency, and essentially human oversight. It's a good idea to align your practices with these evolving expectations already. So Cameron, that brings us to Canada's own AI bill, or the one that almost made it.
Right. So that would be the Artificial Intelligence and Data Act, or AIDA. AIDA was proposed in 2022 under the Digital Charter Implementation Act. It would have applied to high-impact AI systems. These are ones that would affect people's rights or safety and would have required organizations to monitor and manage AI-related risks. So AIDA didn't pass before that session of Parliament dissolved. So for now, it is a non-starter. However, from the ashes of the AIDA did come some useful guidance documents. Innovation, Science, and Economic Development Canada issued a voluntary code of conduct in 2023, and the Privacy Commissioner released principles for responsible and privacy-protective AI. So just to note, these are not laws, these are not binding regulations, they are best practice documents, but even without concrete legislation, the message to you should be clear. There's already an expectation that organizations will handle AI responsibly. So Martin, tell us more about the EU AI Act.
Yeah, so the European Union is leading the way in terms of artificial intelligence law. It adopted the EU Artificial Intelligence Act, or AI Act, already in March 2024. And that was the world's first, and is the world's first, comprehensive AI law. Now, like other EU regulations, like in privacy with the General Data Protection Regulations, or GDPR, the EU AI Act can apply extraterritorially. So that means that even Canadian organizations, including charities and not-for-profits, some of them, who are offering AI-enabled online services to EU residents might be caught by the EU AI Act. And it takes a risk-based approach. So it bans things like biometric profiling, social scoring, and emotion recognition in schools or workplaces. High-risk systems under the EU AI Act need transparency, risk management, and human oversight. And we're going to return to that topic of human oversight shortly, which is really important for AI governance. The penalties under the EU AI Act are quite serious. They can be up to 35 million euros or 7% of an organization's global turnover, whichever is higher. And even if it doesn't apply directly to most Canadian charities, the EU AI Act is shaping global expectations already for what quote-unquote responsible AI looks like. So Cameron, now that we've talked about theory, let's look at what this means in practice.
Great. So one of the leading cases on AI use in Canada is Moffat and Air Canada. Just so you're aware, this was at the British Columbia Small Claims Court. It's called the Tribunal in that province. So the ruling here, it's non-binding. The courts in that province or federally are not bound to follow the judgment here. However, we think that this is the best example of a the legislature, or rather of a legal body deciding on how misuse of AI will be handled. So in this case, a customer of Air Canada was speaking with a chatbot on the company's website. They had asked if they would be able to retroactively apply bereavement fares. The chatbot informed them that yes, this was possible. The customer purchased their tickets, and then after they had taken their trip, they were made aware by a human representative of Air Canada that this was not Air Canada policy, that the chatbot was incorrect, and that the customer would be stuck paying the full price for the tickets. When this went to the tribunal held that Air Canada itself was responsible for the chatbot statement, not the vendor or developer, and not the AI itself, which, interestingly enough, was an argument that Air Canada tried to make, that the chatbot was its own independent entity and that Air Canada was not responsible. The tribunal ruled that the chatbot essentially acts as an agent for the company, and therefore any statements that it makes are done so with the authority of the company. The lesson here is that if your organization uses an AI interface, you can be held accountable for its output. If you are going to use a chatbot, and as this case shows, there is a list of reasons why you might want to avoid doing that. But if that is something you and your organization want to do, ensure that you use disclaimers when people begin engaging with the chatbot. Allow for human escalation, especially when discussing any sort of sale or transfer of money, and keep a record of all your interactions with customers or individuals who are using these chatbots. So, Martin, this wasn't an isolated incident. We're also tracking a lot of other AI-related cases, aren't we?
That's right. We're seeing a growing wave of AI-related class actions, and that can include misrepresentation claims or quote-unquote AI washing, to privacy law claims, discrimination claims, and even price-fixing allegations under Canadian competition law. So the lesson here for charities and not-for-profits is that AI tools can generate convincing and sophisticated, but usually inaccurate information, or there's at least some degree of inaccurate information, even when the output can be relatively factually accurate. So you always need to have human review before publishing any AI-assisted content. And as we're seeing with the decisions in the courts, accountability, first and foremost, rests with the organization itself and not the tool that's developed by the programmers. So Cameron, what's the practical response to all this?
Well, that's where an AI policy comes in. So we're going to look at what an AI policy does and what it doesn't do. An AI policy is your organization's roadmap for safe and responsible AI use. It sets boundaries, defines who can use AI tools, how they can use them, what products are whitelisted or blacklisted. It will protect sensitive data, and it clarifies accountability for AI use generally. Importantly, a good policy should enable innovation. You want to give staff permission to explore AI responsibly rather than banning it outright or making it so restrictive that it stifles their use and you don't have AI actually being integrated into your workflows. An AI policy will build trust by showing donors, funders, and members that your organization is proactive and aligned with emerging standards. What it doesn't do is replace human judgment. AI supports decisions. It doesn't make them. And that, if you take one thing away from this presentation today, it is that you cannot allow AI to make decisions for you, and you almost always need human oversight of AI use. Martin, can you show us how this ties into laws that charities and not-for-profits are already bound to follow?
Sure. So on the next slide, we have some laws listed. And the point is that AI policies should not exist in isolation. They need to be integrated into an organization's existing legal obligations. For example, here we have privacy laws, which require consent and safeguards for personal information, as well as employment laws that ensure that AI cannot override worker rights. Human rights and accessibility laws demand fairness and inclusivity in how AI is used. So when an organization is drafting its policy, it should look at how AI intersects with the laws that already govern your organization. Cameron, let's look at what goes into a strong AI policy.
Great. So the first thing we're going to talk about on that point is governance and accountability. So your policy is going to want to assign clear roles, depending on your organization's size, capacity, and how you intend to use AI and how deeply you intend to integrate AI into your workflows. You may want to have an executive overseer. This person is responsible for the entire implementation of the AI policy. You're going to want to have an AI lead coordinator to implement the policy. They will be sort of a go-between between the executive overseer and the people on the ground that are actually going to be integrating AI into their workflows. You're going to want to bring your privacy officer on board if you don't have one and your organization has the size and capacity. This might be a good opportunity to elect a privacy officer. And you're going to want an IT liaison who is going to be responsible for ensuring that the products that you're bringing into your policy, that you're allowing your employees and volunteers to use, are seamlessly integrated into those workflows. So you're going to want to use a risk-based approach. Simple drafting tools might only need a basic sign-off, while outputs that are going to be going to the public or that have sensitive information in them, you're going to want to have much more stringent oversight of them. We recommend using a simple high, medium, low matrix to assess risk, and the elements of those various levels should be defined in your policy. Consider maintaining an AI registry that lists your approved tools, their purposes, and a risk rating. And don't forget vendor due diligence. You should know how your vendor handles data. If you're dealing with, for example, a smaller vendor, you may want to include audit rights of their data handling practices. This may not be possible for larger vendors, but see if you can have some leverage when negotiating with them. So Martin, let's get into what this means for privacy and data protection.
Yeah, privacy law remains the foundation for AI governance law right now. And so an organization wants to limit the data that it feeds into these AI tools, especially if these are public platforms, for example, ChatGPT. So only use what's necessary, try to anonymize things, generalize, and remove personally identifiable information. And never upload, for example, donor data that's identifiable or beneficiary data or employee personal information to these public AI platforms, or as Bruce McDonald had mentioned earlier in the fireside chat, no proprietary data that could risk your confidentiality. You may want to treat prompts and outputs as records under your organization's retention policy. So that means you want to update your privacy notices if AI tools start to influence decisions about individuals. In short, keep your AI practices consistent with your broader data governance framework. And that same thinking applies to intellectual property and transparency.
Great, I'd love to speak about that. So AI can create new IP issues. Try to verify copyright and usage rights before using AI-generated materials, especially for images or text. That includes both on the vendor side. So some programs, some products, as part of their policy, as part of their user agreements, you will be the de facto owner of any outputs. Now, that's not a blanket statement that applies to all AI products. So you need to verify that. Also, AI products use other information that they gather from the internet generally. So you need to ensure that, let's say you have an AI create a logo, for example. You're going to need to do some due diligence to ensure that you're not infringing on other people's copyright and trademark rights. So be transparent about AI assistance where it matters, like in donor reports or research publications. For sensitive topics, for anything that's going directly to stakeholders, you might want to consider, being transparent about your use of AI in drafting these materials, if it's appropriate, and that would be a decision that you would have to make based on the situation. So, as we touched on a second ago, clarify the ownership internally in your organization. Who owns the AI-assisted work? Is it your staff member or volunteers? Is it yourself, the organization? This needs to be spelled out clearly in your policy and your contracts. Finally, make sure your AI policy aligns with your existing IP and content policies. And of course, as we keep going back to, this only works if there's human oversight, doesn't it, Martin?
That's right. A lot of what we're discussing here today is contextual and depends on your organization and its needs. But as we've mentioned, human review is the most important and it's non-negotiable. So you want to use a two-stage process. First of all, checking for factual accuracy, and then for tone and alignment with your organization's mission and values. We would suggest a quick verification checklist so you can confirm sources, quotes, and anything that your stakeholders may be sensitive about. So for higher risk outputs, you may want to keep a short approval record. And it doesn't need to be strict or formal, but just enough to demonstrate that your organization has done its due diligence and maintained accountability. Cameron, how can smaller organizations start an AI policy without being overwhelmed?
Great. So let's talk about the minimum viable elements of an AI policy. So you're going to want to start small. Define who the policy applies to. List your approved tools. What's allowed, what's not allowed, how are your members allowed to use them. Separate what's permitted and what's not and make it very clear. Include a simple review and sign-off process, data handling expectations, and a plan for disclosure or attribution when appropriate. Make sure you revisit the policy regularly. AI changes fast. Both the laws, best practice guidances, and the technology itself is changing, and your policy needs to change as well. We recommend at least reviewing your policy once a year. So let's wrap up with a few key takeaways here.
Yeah, first of all, AI is already here. It's rapidly developing, as we all know, and a strong AI policy enables an organization to use it safely and effectively, not only to stay up to date with best practices, but also with the prevailing standard of care and avoid any potential negligence claims.
As I said a moment ago, start small. Consider piloting AI internally before expanding to public-facing uses. Allow your members to use it in situations where it's low risk and any sort of error will be easily detected.
Thirdly, and perhaps most importantly, keep a human in the loop. This is really as we've said, at the risk of being cliche, you always want to have human oversight and always have a human being review outputs.
Protect all your client and donor information and stay aligned with your privacy obligations and privacy policy.
And finally, as we had just mentioned, review and update your policy regularly. Again, this is a really rapidly developing field, and we recommend at least an annual review to update for whatever changes and developments have occurred over the past year. AI is not a one and done issue.
So remember, the goal of a policy isn't to hinder or stop people from using AI. It's to empower them to use it safely and confidently and effectively.
Thanks everyone for your time.
And if you'd like to talk more about developing or tailoring an AI policy for your organization, please get in contact with either of us after the session. Thank you.
Great. Well, thank you, Cameron, and thank you, Martin. It certainly is a brave new world. AI is touching on a number of things, and it's not going everywhere. It's always changing, and so thanks for getting everyone up to date. Keep the human in the loop. Don't let the robots win. So we want to make sure that happens. All right. Thank you, guys. We're going to move on over to two partners with our firm that many of the lawyers call on all the time for all things real estate and all things commercial leasing, as well as other things. But I'd like to introduce my colleagues and partners, Nancy Claridge and Adriel Clayton, who are going to be talking to you about a bit of a different topic over to dirt law. Over to you guys.
Thank you, Ryan. On behalf of my partner, Adriel, I'd like to thank you for coming to listen to us talk about dirt law. You might see from the title that Adriel and I are both singers, and we wanted to do a big presentation, but Terry vetoed that. So you'll have to just listen to us talk today. But I did want to assure you that you do not have to hold back your joy of listening to real estate topics. Like, who doesn't get excited about title insurance, co-ownership agreements, property tax exemptions, and new legislation that will impact our physical buildings, Bill C9.
Thanks, Nancy. I know title insurance is certainly an exciting one for me. Every time, I meet with clients, I get the question, well, why should I get a title insurance policy? What is it even? So I don't know if you can maybe walk us through that, Nancy.
Thank you. I think most people have a title insurance policy, but they don't necessarily know what it's for, and probably didn't remember about it when they purchased property. It is often not an option when purchasing or refinancing real property. And unlike traditional insurance, we talk about it being a one and done, but it's also looking at future incidents to ensure the marketability of title. And so we look at a number of different issues, such as unknown title defects. So that can be errors in public records or the land registration office, existing liens that perhaps were not cleaned up as part of the purchase process and has now become the new owner's responsibility. Boundary and encroachment issues are things that we do talk about a lot. So is that fence on the boundary line, or is it over? Zoning violations. Does your building actually allow you to carry out the activities that you do? And what we may not have thought about in the past, but is certainly a very important issue, title fraud. Is somebody pretending to be you to transfer the property or to mortgage it and leave you with the responsibility for that? So instead of having to deal with these problems yourself, title insurance is there to pick up the pieces and assist you in rectifying these problems. Now, as I said before, a lender policy is generally mandatory, and an owner policy is optional, though we would strongly recommend that it be obtained. Now, Adriel, can you talk to us, what are the new issues in title insurance?
Yeah, absolutely. So, everything that you've kind of walked us through, Nancy, that's kind of the basics of title insurance. That's been in place for a good long while now. But there has been a bit of a change, not so much in terms of title insurance itself, but just in terms of the processes that we all have to go through to obtain title insurance as of October 1st of this year. So there's some new compliance duties that are being placed upon title insurers. They've been added to the list of reporting entities that have to report certain information under Canada's money laundering and terrorist financing legislation. They were added largely because anytime you're dealing with real estate, that's a huge purchase. That's a lot of money that's going back and forth. So there is the potential for a real estate transaction to be used fraudulently for money laundering, conceal beneficial ownership indirectly. So as a result of some reviews that happened over the last few years, title insurers are now being asked to report certain information to FINTRAC, which is Canada's anti-money laundering and anti-terrorist financing agency that they collect and analyze data and try to prevent money laundering throughout the country. So the types of things that they're being required to collect and report on, they're now required to verify the identity of those who are obtaining title insurance. They need to know certain details about the transaction itself, the names of the purchasers, whether it's an individual or whether it's a director of a corporation, their dates of birth, the property that we're actually transferring, who the lender is, who's selling the property. And so for the longest time, this is all information that we as lawyers would be collecting from our clients in any event. But going forward, lawyers are now being asked to act as agent on behalf of the title insurers to collect this information and pass it along to them.
Yes, Adriel. So we now have to look at what are the different options for the purchaser. And we've indicated that there's possibly three options. One is to consent to the lawyer acting as that agent and providing all the necessary information, but making sure that we comply with the Law Society and don't breach our solicitor-client privilege. The other alternative is to go and not consent to the lawyer acting as agent, but allow the lawyer to provide the contact information so that the buyer can go and provide the information directly to the title insurer. The third option we put down is not necessarily a real option. It's don't consent and just don't go with title insurance. Realistically, we know that most lenders are going to require title insurance, and as we said, it is certainly something that we do recommend for the owner as well. So what does that mean for charities and not-for-profits who are purchasing property? It does mean that there is an increased request for information. Directors and officers may not have in the past been participating in providing all the necessary identification up front, and it might have been something that firms would chase later down the line, but we need it up front early to get it over to title insurers. We don't really see this as being a huge burden. It is something that has always been expected, but it's now more information that we're going to hand over to the title insurance. So it is important to make sure that everyone's keeping all of their documents up to date. And as far as that goes, make sure that you are talking with your lawyer and your finance teams early so that this is not a panic.
All right, thanks, Nancy. The next topic that we're going to be talking about is actually one that I've been seeing a lot more frequently recently, something that I actually really enjoy working through. But so we're talking about co-ownership agreements, and these are basically agreements that, two organizations, in our circumstances, frequently two charities that want to purchase a parcel of property together and operate from it, separately while owning the property together. So, I really suspect that this is something that's kind of that we're going to see a lot more of going forward. It's certainly an option for any organizations that are considering purchasing property, but maybe you can't afford it. But if there are two organizations that are able to put their money together, maybe you can purchase a more centrally located property that you can both work from.
Absolutely. Now, I wanted to take a little step back just to make sure that organizations always consider, before they go down the road of doing a co-ownership agreement, clearly assessing whether or not co-ownership is right for your organization, or if leasing is something you should continue with. So we've set out a number of different issues: control, cost, risk, exit strategies, and suitability between the different organizations that are owning it. It's very important to make sure that you're doing a proper assessment in order to make the most of such a transaction. Now, Adriel, can you talk to us about what are the key ownership provisions that you would put in an agreement?
Yeah, absolutely. So anytime I'm putting together an agreement, the first one, and this might seem a little bit obvious, but the first key question is going to be, well, who is owning, what share of the property? It's not necessary that both parties come together and say, okay, we're splitting this 50-50. Perhaps you got one larger organization and a smaller organization, and the larger organization is, I don't know, maybe purchasing a 75% share, and the smaller organization only has the funds to purchase a 25% share. So, who's going to be contributing how much to the property going forward? Both in terms of the purchase as well as ongoing maintenance. What happens if you end up, for example, leasing it out to a third party? What happens to the funds that come in? How is that split? Are you both using the same rooms in the property, or are you not? How is that going to work out? It's a lot of just kind of practical thoughts that you have to kind of put into it. How are you going to operate the property on a day-to-day basis? And the last one that I like to kind of remind people about, I don't like saying it this way, but you kind of have to treat it as a prenup a little bit. We're in this together. We're trying to work through this together as best as we possibly can. This is a long-lasting relationship, but we still want to plan for what happens if one party wants out or if both parties want out. How do you sell the property? What happens if there's a dispute? How do you work through all that stuff?
Absolutely. Now, from a charitable compliance side, it's important to make sure that when you're acquiring this property, that it will align with your charitable purposes. I don't want to go deeply into the issue of related business issues. I do want to caution that you speak with your charity lawyer on those issues because you might go offside if this becomes an investment only. And just generally maintain all of your documentation so that you can ensure compliance with the CRA requirements.
All right, so the next topic that we're going to be touching on is going to be property tax exemptions. Always a bit of an exciting one because we're looking at ways to help you as a charity or not-for-profit save a little bit of money in taxes. Put some more of that money in your pocket towards the good work that your charity or not-for-profit is doing for the community. So very broadly, very broadly. Property tax is it's not a federal matter. It's more of it's governed provincially. So every single province is going to have different rules. Given that Nancy and I both practice in Ontario, that's what we're familiar with. So just our discussion going forward is kind of going to be more centered around what we're familiar with, being the Ontario's Assessment Act. But there is, as you can see in the slides, a similar assessment act throughout other provinces. And for a number of those provinces, we do have links. You can actually click on those hyperlinks when you do download the slides, and they'll take you directly to each provincial assessment act.
Thank you, Adriel. So in Ontario, our primary focus is on the Assessment Act. And it governs basically the issue of who is taxed and who is not. The basic premise being all real property is taxable unless it is specifically exempt. Now, exemptions are based on property use, not owner status. So I want to repeat that. Exemptions are based on property use, not owner status, which is very important to consider because a charity may own property and it may not be exempt. It may own property and it may lose its status as an exempt property. It may become a mixed use property, so it may have partial exemptions. So it is important to look at what is the direct and primary use of that property in order to determine, does it fall within one of the exemptions under the Act? Adriel, can you talk to us about the Municipal Act and how that impacts charities?
Absolutely. So if your property is not subject to an exemption, then there is a second option to look into. It's not going to give you a full exemption to your property. It's not going to say, you don't have to pay any property taxes at all. But the Municipal Act in Ontario does grant certain charities, certain organizations, a rebate of the property taxes that you've already paid of up to 40%. So this is something that differs from city to city, from town to town. So you'd have to kind of look into your specific municipal laws and municipal bylaws in order to know whether your organization might be exempt. A lot of these sorry, not exempt, but whether the rebate is available to you. And for a lot of these organizations, the rebate is available if you're a registered charity. What we've done as well is we put together a tiny bit of a checklist to kind of help you walk through and do a little bit of an assessment to see how to approach this. So the first question is that you're going to ask is whether the property is owned or occupied by a charity or not-for-profit. Of course, that's not the be-all and end-all, as Nancy said earlier. We're not looking at who owns the property, but what the property is used for. But it's telling, you know, if you are a charity or not-for-profit, because the follow-up question then is, well, is the property being used for a charitable, religious, educational, or public purpose? And that's, in Ontario, at least, that's a very broad generalization. You still really need to look into the various exemptions that are set out in the Assessment Act. And I tend to recommend that charities, you know, reach out to their lawyers to ask these questions, to ask if there is a potential exemption, just because the Assessment Act exemptions can be quite specific. So you really want to speak with a lawyer and kind of go through that list and do an assessment with them to see whether you fall under any of the exemptions in the Act. If not, then then it's time to look into that municipal rebate, which is, you know, not quite as great, but 40% still something back.
Thank you, Adriel. Now, we did hint at the possibility of losing your exemption. So what are the common pitfalls that we have seen that would jeopardize exemption? Primarily, I've seen that in with respect to leasing to third parties. Those commercial tenants could void that exemption if their use doesn't fit within what the Assessment Act provides. It can also you know, result in loss just by the failure to update your municipal records and maintain your CRA documentation. And even just missing your deadlines that MPAC sets out for any assessments or reassessments. So it's important to kind of monitor what what's happening with your property to maintain those exemptions. Adriel, can you talk to us about that mixed-use property calculation?
Yeah, absolutely. So I'm just keeping our timing in mind. I'm going to keep it very simple. But basically, you know, if you're using a certain percentage of your space for an exempt use, then you're going to be able to, or arguably be able to, get an exemption for that percentage of the space that you're using for the exempt purpose. So let's say, you know, you're using 60% of your space for something exempt, like an educational institution or a place of worship. Then you know, and the remaining 40% is taxable, then you'll be paying 40% tax.
Yes, sir.
So that's kind of very a very brief overview. We have set out a bit of a checklist, a best practices checklist for you know, how best to do this. I'd encourage you to read through this list as we go forward. I just do want to get to the very last topic, if that's okay, Nancy.
Absolutely.
All right, wonderful. So the last one then is this new legislation that you know, helps to protect places of worship. It was introduced in September. It's still under review, so it's nothing that's overly, you know, it's not official yet, but it is being reviewed and it is kind of moving its way through Parliament at this point in time. It targets hate-motivated intimidation and obstruction. And basically the idea is to protect access to places of worship. So it's to prevent hate crimes from happening in front of you know, places that are like places of worship, places of education, community centers, just to kind of protect the community a little bit better.
Now, what are the key provisions that we need to consider for as far as property is concerned?
Well, it sets out a definition for hatred, but in terms of, you know, the actual property itself, it's going to criminalize willful intimidation of people that are accessing these properties. So again, just to kind of really simplify, the idea is to protect you know, these properties and those who use and access these properties by, you know, creating a criminal offense for those who enter onto these properties and start intimidating people.
Thank you. So the implications for charities and faith-based groups really is to just have this on your radar. As you can see, it's only at second reading right now. It could possibly not proceed forward, but it is just the thought now to have a good, especially with the way things are today, have a look at what your policies are as far as your property risk assessment, and ensuring that you're looking at what are the policies you have in place with respect to the issue of possibly being targeted. It's important to understand that while this provides some protection, it is not meant to criminalize peaceful protest, assembly, etc. So something to consider. Make sure that you're reviewing your leases. If you're in a leased building, to check what are the policies for access and when do things need to be reported, and what is your communication process with the authorities. But keep this on your radar, and we will see how this develops in the future. And I think that's all for us today, and so I will throw it back to Terry.
Great. Thank you, Nancy. Thank you, Adriel. You covered a ton of topics under the dirt law category. Very much appreciated. We're now going to move over to presentation by Ryan, co-chair, co-host. Ryan's going to be dealing with the topic of from governance to grievance, a legal look at members' rights. I like to describe this as kind of like a bun fight within the family. We're going to hear about what members can do to each other. So over to you, Ryan. Thanks.
Great. Thank you very much, Terry. So as Terry said, we're going to get into a look at the rights that members have. So a quick question. How many members does it take to completely derail a membership meeting, derail a board's agenda, and to cost a charity or not-for-profit probably tens of thousands in legal fees? It only takes one. It takes one member. It only takes one cranky member. So we're going to be looking at, a lot of the power that members have that they can and should use, but that is sometimes forgotten by boards that members are there. So here you'll see an overview of the presentation. What we're going to be talking about is, in general, the rights that corporate members have in Ontario and federally under the Ontario Not-for-Profit Corporations Act 2010 and under the Canada Not-for-Profit Corporations Act as a federal piece of legislation. So if you're incorporated as a society in a different statute, in a different province, a lot of this will still be applicable to you. Members' rights in general don't vary too much from statute to statute in Canada, but we are looking at the rights of corporate members under not-for-profit legislation, primarily in Ontario and Canada. So when clients come to talk to many of the charity lawyers here or myself, and they maybe want to do something like Jackie was talking about earlier, like amending their purposes, or maybe they're looking to amalgamate or make some changes to their bylaws, we often tell them, well, as a first step, you're going to have to take it to the membership and get the membership to approve that. And you'd be surprised at the number of times that we get asked, does our corporation even have members? Or who are the members? Or how many members are there? For a lot of charities, they can hum along and everything's fine until they get to that roadblock and realize, oh, it's actually quite a big issue now for us to get members. So yeah, every not-for-profit corporation in Canada has members. There's maybe a minuscule fraction of special act corporations where that might not be the case. But in general, in Canada, all not-for-profit corporations are membership-based. Well, what does that mean? Well, membership can be structured in a number of ways, just like lawyers and accountants like to get crafty coming up with share provisions for a for-profit corporation. Membership can be structured under the CNCA or the ONCA in a multitude of ways. So membership can be divided into different categories. Some members can have certain rights. Some members cannot have those rights. So just like when you're boarding Air Canada and you can have a Zone 1, a Zone 2, a Zone 3, you can have members that are having different rights as well. Generally, we look to the incorporating documents for charities and not-for-profits to see where the membership classes are set out. If they are, they should be. And with respect to those that are federally incorporated, if they're non-soliciting corporations, so essentially if they're not charities and they're not fundraising too much from the public, they can also enter into a structure for their membership by adopting a unanimous members agreement. So what is a UMA? Well, in essence, a UNA is an agreement where the membership restricts some of the power of the board and hands that to themselves or delegates to that themselves. It's usually only used in a few circumstances. We don't always recommend it because if you give some powers of the board to the members, those members then might also have the same liabilities as the directors. So it's important to think about that as a caution. Just to get it out of the way, one big right that members have, as I mentioned before, is members are the arbiters of whether or not certain fundamental changes can happen. So, if, as I said before, if there wants to be certain changes to membership conditions, if there wants to be certain changes to the purposes, if the corporation wants to change its name, those are all things that are deemed under not-for-profit legislation to be fundamental changes. And so what that means is membership gets a right to vote on those. Sometimes it might have a higher threshold called a special resolution, where 2/3 of the membership has to approve that, or it might be an ordinary resolution. But in general, these fundamental changes are something that the members have to approve, and they require a special resolution. And in Canada, if you're incorporated federally, even if you've gotten crafty with your membership structure and you've decided that you're going to have some non-voting classes of members, those non-voting members get the right to vote, even if they don't have the right to vote on those fundamental changes, if it's triggered by subsection 189 of the CNCA. What are those? Well, in general, those are all changes dealing with changing conditions of membership or rights that certain members have. There are some carve-outs to those that can be put into the articles for a not-for-profit corporation that's federally incorporated, but that's not always the case. When the ONCA was originally being drafted many moons ago, it had language that mirrored what was in the CNCA in terms of those protection, like minority shareholder rights for members for certain fundamental changes. That's no longer the case in the current iteration of the ONCA that we have. So in Ontario, at least, you can have non-voting members that are truly non-voting. But even if you have a multitude of classes of voting members, those members get to vote on the fundamental changes that the corporation wants to make. Okay, so one member, one vote, one headache for the board sometimes. So the members have the power to vote, and that can be paramount to what goes on in the organization. The board is accountable to the membership, and so their ability to vote on different matters that come up at membership meetings is very important. Now, as I said before, you can arrange a number of structures for members in terms of setting out who gets to vote or not. You do have to sort of be careful when drafting the articles and the bylaws that if there are going to be 2 or more classes of members, that at least one of them gets the right to vote. And if the corporation wants non-voting members, you'd have to set it out in the articles as well, because otherwise there are a number of defaults in corporate legislation that give voting rights to members. So as much as some boards might want, you can't have a class of members that's just one class that's non-voting. There must be at least one voting class in the organization. It's also possible to set out a number of variations with respect to that. So you can have some classes of members each having more than one vote, or you can have a formula. So certain members, depending upon, for example, how many people might be involved in their organization, if they're a corporate member or things of that, having more weighted voting. So it's important to be aware of, if you do have to get membership approval for things, that you take consideration of the number of classes that there are, together with what particular rights they might have in the bylaws or articles. Now, in addition to the right to vote, members get a lot of rights to corporate access for various records that are required to be kept under the CNCA and the ONCA. You can see a number of these have been set out here. Of course, the members can ask for the birth certificate for the corporation, the articles. They might also want to get bylaws or financial statements. There's a number of other things here as well. Now, the corporation can put up a bit of a roadblock in the sense that they can ask for payment of a reasonable fee. But in general, if you are a board member or an executive director of a charity, you don't want to try to deny a member getting any of these documents. Some people might say, oh, well, there's privacy rights. In most cases, the corporate rights that members have will trump those, and they'll be able to have their access to get these registers. I will say something that often comes up is that, if a member is asking for meetings of committee minutes and the corporation didn't know that they were required to keep minutes of committees, oops, it's kind of hard to produce those documents. So when you look at this list, you want to make sure that these are in fact all things that the corporation has ready and available in case a member requests to see them. In addition to that general corporate information, there's also the ability for a member to request the register of members, subject to making a statutory declaration. So there's a certain form that needs to be filled out. Now, members can't ask for the membership register just for any old reason. They can't ask for the membership register because they want to show everyone their vacation trips to Banff or something like that. They have to make sure that it's going to be used to influence voting or to be used to requisition a meeting, things of that nature. And both the board and the members themselves can go to court if they think there's going to be an issue with getting that membership list. But it's important to make sure that that's available. You look at that first bullet point there, it says the register has to contain the names of current members, former members within the past 6 years, their address for service, their email address, and class. So a lot of times corporations just don't have those. So it's important to make sure that your registers contain all the prescribed information that's going to be required under statute. Now, as I said before, it's not a smart idea to put up any roadblocks to membership. I make reference to this case here that Hemming and Jazz FM 91, for those of you that are jazz aficionados that might be in the Toronto area. This was a decision under the former Corporations Act, but it involves the refusal for the membership list to be disclosed. And I provide this here not as a fact that it's a great case and you want to go read that, but I did like this comment from the bench which said that it's best to deal with dissident groups is at a meeting where they get to either stand or fall. Tossing roadblocks in the way of democracy is not very helpful use of the corporation's money. So for a lot of times where members are trying to exercise their right to access certain information, if the board is putting up roadblocks in the way, they're not going to be looked on very favorably by the courts. Okay, so an indecent proposal to maybe amend bylaws. So in this sense, in addition to the right to vote, in addition to some of those access rights that members have, members also have the right to make a proposal for things that they want to see discussed at meetings. So this is a right for voting members. I should go back and say that for some of those corporate access rights, those are also available to non-voting members, even if they don't have the right to vote. So, sometimes people want non-voting members because they think no harm, no foul. It can actually come up with a few different issues for the organization. Now, with respect to proposals, anyone can put forward a proposal provided that they want to follow the rules that are going to be in the bylaws or statute. A voting member can submit a proposal to amend the articles, or they can put forward an amendment to repeal or change the bylaw. But at least 5% of the membership can put forward a proposal as well to nominate directors. So sometimes organizations will try to control, when nominations happen, who can nominate, whether or not people can nominate from the floor. They're always going to be kind of frustrated by the fact that voting members, where at least 5% of them have put forward a proposal, can nominate directors. And so it's important to try to not get in the way of that unless the members haven't followed the rules under the statute. So when can a board refuse including a proposal in a notice of meeting? So a lot of times when we as lawyers are asked by our clients, a member has put forward this proposal, we're trying to attack that proposal or requisition, which I'll talk about in a minute, by seeing whether or not there's an ability to deny it. And the fact is, there aren't really a lot of reasons why a board can deem not to include a proposal. There are some exceptions that the statutes provide, such as where the primary purpose of the proposal is to enforce a personal claim or maybe redress a personal grievance, or if the proposal doesn't relate in any significant way to the activities or affairs of the corporation, or if you're just trying to abuse the right to secure publicity. But those are very narrow limits to when a proposal can be denied. And you'll see I have another case reference here as well, which I'll get to in a moment. But just as a member can put forward a proposal, members with a little higher threshold of 10% can also requisition a meeting. The bylaws can set a lower threshold, but in general, you don't really want to. And so the same thing, when a board receives a requisition to hold a membership meeting, it's important to make sure that, of course, the member needs to have complied with the bylaws and statute to do that. But again, there are just narrow grounds in which the board can deem not to requisition a meeting. And that can be, well, they've already called a meeting, so it's a bit moot to try to requisition a meeting when there's already one coming up. Or if the business stated in the requisition is improper. And so that can refer back to the same grounds that are set out for, proposal rights, where they're just to have a personal grievance or personal redress dealt with. So just as I did with the Jazz FM case, I just have another brief case here, just because I want to cherry pick some quotes from it. But this is a 2015 case that was under the Canada Not-for-Profit Corporations Act, but it's the Saskatchewan WTF Taekwondo Association and Taekwondo Canada. And there the board was trying to say that they did not want to have a requisitioned meeting because they felt that the primary purpose was to just address a personal claim or a personal grievance. And in that situation, the court held there was no basis for characterizing the motives of the members who requisitioned the meeting as being in the nature of a personal grievance. So the words mean something when it comes to those exceptions in the statute, and clearly is referred to as meaning only those requisitions which are clearly personal grievances are to be rejected. So for boards that want to try to not have a proposal circulated or not call a membership meeting on those grounds, the threshold is very high if you're going to say it's for being a personal grievance or a personal redress. So better not to try to throw roadblocks in the way of members exercising their rights. All right. One of the board's least favorite rights. A lot of times clients ask us, hey, what happens if the board doesn't follow these bylaws? Or what happens if the board doesn't follow the statute? And sometimes it can happen where, what the non-compliance that's happening is, well, they're offside some of their obligations with the Income Tax Act, or maybe, they're not using charitable property in a way that they said they would. And that can get some regulators like CRA or the public guardian and trustee involved. But for a lot of times, if it's a straight matter of corporate governance and, failure to comply with the bylaws, no one's coming. There's no regulator that's going to help with that. That's where the statute sort of puts the power in the hands of the members to exercise their voting rights. And one of the ultimate powers they have is to remove directors before the end of their term. So it's not a show cause hearing. The members don't have to prove that the board member did something wrong. Members get a right to remove board members by ordinary resolution. And so it's quite a powerful right that they have. I just want to point out quickly that members can also remove the auditor or the public accountant. Makes sense because, when you're going through your AGM, the members also have to approve the appointment of the public accountant or approve the appointment of an auditor. I've never seen members boot the auditor before the end of their term, but it's important to be aware that that is something that they have the power to do as well. I did have on this slide, just very quickly, some process that needs to be followed if an auditor is removed, just to make sure that the new auditor coming in at least goes through the process of requesting the reasons why the previous auditors were removed. Otherwise, that appointment might be void. Now, members behaving badly. So members can easily ask directors to leave and sort of show them the curb. Not so with members themselves if the board wants to discipline them. So both the ONCA and CNCA give members rights on discipline, and basically it requires that there needs to be a minimum of procedural threshold for the members to be removed. So with the with the CNCA, it's a bit more less prescribed in the sense that the statute says that, well, if there's going to be a process to discipline or remove members, you have to set it out in the bylaws and articles, and there does need to be some minimum procedural threshold. But other than that, it's up to the organization to come up with that in their bylaws. The ONCA does go a step further in the sense that it requires good faith and that any discipline needs to be done in a fair and reasonable manner. So that prescribes a minimum of 15 days notice. Now, in practice, the difference between the ONCA and the CNCA is not that great because a CNCA corporation is going to want to provide a minimum of notice as well. But it's important to be aware that members do have rights when it comes to being removed, such as the ability to, be heard and respond to any reasons for why the board might want to discipline them. So I'll end quickly on just some membership remedies that organizations can have. So just as members, they have the power to make sure that the board's on side by removing directors. They also have the power to apply for certain court remedies, and that can include an oppression remedy, court-ordered liquidation, seeking a derivative action, or a compliance or restraining order. So an oppression remedy is available under the CNCA, and that's basically an application that can be made where the members feel that their reasonable expectations are not being met, that they're being oppressed. So they can go to Pharaoh and say, let my people go. And the court can craft an equitable remedy for them that can be very broad. They can remove the board, they can have a mulligan on election, they can do a number of things to make sure that that oppressive conduct is stopped. Members can also seek a derivative action where they can apply to court to be able to bring an action in the name of the corporation if the board's not doing that. There are some exceptions in the ONCA and the CNCA for religious corporations. The ONCA exclusion is a bit broader in the sense that you can't seek a derivative action if there's a tenet of faith that's involved, but there you go as well. You can also seek an order ordering the board to comply with the act, or ordering them to comply with their bylaws. Or if they're trying to do something like sell land and they haven't got a special resolution for that, that they can seek a restraining order for that. Again, there's another brief reference to a case here dealing with a compliance order under the ONCA, where the court found it can also even be sought by non-members. So sometimes non-members will have rights as well in our corporate bylaws. So I'm going to wrap up there. Just a few key takeaways. Members are important. Members have lots of rights. You want to make sure what rights they have by reviewing your articles and bylaws. If you're wanting to limit those, to clearly set out what their rights are in the bylaws and membership qualifications so that you're aware of who's coming in, and determining who is or who may not be a member, and which class of members should control the corporation is a very important step for proper corporate governance. Thank you.
Oh, that's great, Ryan. Thank you. Let my people go, Farah. That's great. All within the bun fight of corporate membership. Thank you very much, Ryan. Appreciate that. We're now going to move into our next and last fireside chat. We've got Ken Hall. Ken Hall is the president of Robertson Hall Insurance and has a tremendous amount of experience in the insurance area. And we wanted to have Ken join us today to talk about some of the challenges in securing and keeping insurance for charities and not-for-profits. So, Ken, thank you very much for being available, and we're looking forward to our discussion together. So, Ken, just going to dive into it with you. I think it's fair to say it's not getting any less complicated these days with all the challenges that we're having to deal with business and not-for-profit, including purchasing effective insurance protection. So I know that our legal clients are increasingly expressing concern, not just about affording premiums, but also being able to get insurance or certain coverage. Ken, you've got 35 years of experience, just a wealth of experience in dealing with claims, and I think you've indicated you've dealt with 14,000 claims. Can you highlight for us some of the current challenges being faced by charities and not-for-profits, including identifying some of the risks they face and finding effective insurance solutions? So, Ken, welcome, and look forward to hearing from you.
Well, thank you very much for inviting me here today, Terry. Although I have to admit, as the insurance guy in the room, I'm having mixed feelings about this roaring fire in the background. So I brought this along just in case.
Thank you.
Yes, there are definitely some challenges in finding effective liability and property insurance protection, even in understanding the coverage options that are available and most needed in a claim. And you put that together with budgetary pressures that are faced by a lot of not-for-profits, and there's the temptation to purchase cheaper insurance, and it can result in neglecting important protection. And buying inferior insurance or underinsuring by justifying short-term savings to have more money to put in programs or ministries is, in our experience, a long-term recipe for disaster, both for the organization and also for current and future directors. It's a sort of a wing and a prayer approach, and it often backfires with serious ramifications for the organization's leaders, for the assets and the ability to continue to operate. And I want to talk, we'll focus a little bit today in our 5 points, but there's infrequent but severe risks. We don't think about them every day. They may not happen to us in a lifetime, but they can cause financial hardship, bankruptcy, or place directors and members at risk from a personal liability standpoint. In the insurance world, we call it frequency or frequent claims versus severe claims. But in plain language, it's the "it can never happen to us" mentality. And I think we all suffer from this. We tend to focus on risks we understand, that happen within our experience, and we neglect the things that don't happen often, but they can and do happen to the best of organizations.
Well, thank you, Ken. Appreciate that. So maybe let's get started with maybe 5 major insurance challenges for charities and not-for-profits. one of the pain points that we hear about from our clients, at least on a regular basis, is about obtaining insurance protection for physical and sexual abuse claims. Not just for organizations working with children, but also those who provide services for vulnerable adults in their community. We even hear directors from organizations who don't have abuse coverage asking us, quote, "Am I going to lose my house?" And Ken, given your experience in insurance with charities and not-for-profits, are you able to speak to the issue of the availability of this important type of insurance coverage?
Happy to do that. Abuse liability insurance is definitely top of mind for most of our church, charity, and not-for-profit organization clients. And the theme today, I guess, is a little bit about the inside scoop. So the participants on this webinar might want to know there's nearly 2 significant amalgamation during the past 3 decades. About only 15 companies hold 80% of the market share. And along with that, insurance companies are not required to provide abuse liability coverage. And because of what's known as a long tail exposure associated with abuse claims, I'll talk about that later. Under the statute of limitations, usually victims only have a year or 2 to file a bodily injury claim, but the limitation period is waived for childhood victims of abuse. And they can make historic claims years or even decades after the abuse. And that makes it really challenging for insurance underwriters to quantify the risk from an actuarial standpoint and to even know what premium to charge for future claims. And the bottom line is we're down to only a handful of insurance companies who will provide full limits of abuse coverage, and the vast majority are issuing policies that contain standard exclusions for abuse claims. So there's definitely been growing concern about long-term availability amongst for-profits and not-for-profits who operate programs for minors and also for vulnerable adults.
That's sobering reality, Ken. So thanks for sharing that. Can you give us any practical advice for organizations that are struggling to find abuse liability coverage in the current marketplace?
Well, first off, I'd like to say that amongst our own client organizations, about 70% have qualified for the coverage. So from my perspective, as well as other niche brokers working in the not-for-profit sector, including faith organizations, there's still coverage availability, but it's not like home or auto insurance where you have access through any local insurance agent or broker. And so for effective protection, you need to find the right insurance provider who specializes and one who can guide you through the process of applying and qualifying based on your organization's abuse prevention policies, procedures, screening measures, and so forth. And even if you do find abuse liability coverage, I want to bring up the very important point: not all abuse liability insurance policies are created equally. In fact, far from it. And if you're on this webinar today, and if you're an organization that operates programs or ministries for children or vulnerable adults, if you remember nothing else from this insurance chat, and if you're shopping for abuse coverage, you should insist on occurrence form abuse liability and not claims made coverage. Occurrence form abuse coverage is the gold standard because, as with many forms of protection, it has an obligation to defend and cover claims that occur during the period of coverage. Doesn't matter when the lawsuit is made for the claim, whether it's now or years or decades in the future, or even after your policy ends. It's a permanent promise of protection, and it's crucial in terms of what I discussed earlier about victims being eligible to sue far into the future because of the statute of limitations being waived. Unlike the permanent nature of occurrence form coverage, a claims made abuse policy in effect only has a temporary obligation to cover abuse that occurred during the policy period. And the lawsuit actually has to be made during the time frame of the coverage with that insurer. So the problem is that if the organization should, for any reason, change insurance companies in the future, whether they cancel you or the organization switches because the premiums get too high, the prior insurance company no longer has any obligation to cover a claim that occurred during their period of policy. It's a permanent gap in protection. And it's one that can last years or decades long, however long you're with the insurer. So it's particularly problematic because in our industry, insurance underwriters do not provide retroactive coverage for abuse. So there's no new insurer out there waiting to save the day and to cover and backfill coverage for this. And for good reason, they have no idea what's hidden in the past or what standards of prevention were in place decades ago. So we're still seeing claims coming forward against organizations from incidents that happened in the 60s, 70s, 80s, 90s. But if the organization has kept historic record of their insurance, and that's very important, I want to emphasize that, keep your records, your insurance records, your liability policy records. And if they have occurrence form coverage, the insurer from that time period still has the obligation to fully defend and cover the organization, including your past and present board members.
Yeah, Ken, I just want to just concur with you. Keeping records, insurance policies is so important. When we're contacted, problems dealing with abuse claims, it's the first thing we ask. And generally speaking, with a volunteer organization, whether it be a church or a community group, they don't have great records, and it's really problematic to be able to track down what insurance they had or didn't have at that time. Ken, speaking of board members, based on your experience, are you seeing challenges for organizations in understanding and buying directors and officers liability insurance, or is commonly known as D&O coverage?
Yeah, great question, Terry. Directors and officers of charities, who are often volunteers, they may lack expertise in fiduciary risk and insurance. It's not their wheelhouse. They're volunteering their time and their resources and their abilities to further the organization's objects, but it doesn't mean they're insurance or legal experts, as you know. So there can be some fundamental misunderstandings about what a D&O policy can and cannot cover. Our office gets calls from a board chair member asking for D&O coverage only often, not realizing that also having a general liability policy is an essential cornerstone for the protection of both the organization and the board. And that's because a general liability policy covers key areas of risk, including bodily injury and death, personal injury, and third-party property damage. If you're ever suffering, Terry, or any of you there, from a really bad case of insomnia late one night and decide to read through an entire D&O policy from cover to cover, you'll find that the three main exclusions in the policy are for bodily injury, personal injury, and property damage. So without a general liability policy, neither the organization nor the directors have any coverage for those risks. So back to D&O liability, directors and officers liability, and what it does cover. Most standard policies cover, and this kind of rolls off my tongue, I've said it so many times, but I'll try to slow it down, actual or alleged negligent acts, errors, omissions, breaches of duty, neglect of duty, misstatements, and so on. The risks that are not covered in a general liability policy. And they're mostly related to fiduciary duties and financial responsibilities that boards have on behalf of the corporation or the organization. And by the way, ones they can be held personally liable for. So a comprehensive D&O policy, what should it have? It should definitely include employment practices liability insuring agreement. Some D&O policies don't. But this is to cover certain claims and damages that arise from things like wrongful dismissal, employment-related humiliation, harassment, and other things. However, even a D&O policy will not cover damages in a lawsuit for an organization or board failing to pay salary, bonuses, severance. In other words, directors can't rely on the D&O policy for a shortfall in compensation that they owe under an employment contract or under ESA or common law. Another risk a D&O policy doesn't cover are breaches of other contracts. You can't rely on a policy to make good for defaulting on the terms of a mortgage or a purchase and sale agreement to pay what you otherwise owe under contract. In terms of what is covered, you need to look for D&O policy, a broad form policy that includes legal and other defense costs of a claim, coverage for your board members if they're required to serve on outside directorships as part of their duties in the bylaws, and also a very growing area these days, coverage for defense of human rights tribunals and boards of inquiry. We're seeing more and more of those. Most D&O policies don't cover that, some do. And before kind of leaving this section, another important point that's missed by a lot of organizations when they purchase a D&O policy is retroactive coverage. Remember, a D&O policy is also claims made, meaning that if a policy is ever non-renewed or canceled, including changing insurers for a better policy, all the coverage for the previous policy period is lost. But unlike abuse coverage, many insurers, D&O insurers, will give what's called retroactive coverage for prior unknown acts. So it does fill in this gap that claims made sometimes creates. But what you want to make sure, and this is insurance speak, but this is what you want to ask for. You want to know that your new D&O policy does not contain a retroactive limitation date. Matters for unknown prior acts, for things that are not known to the board at the time of application. You want coverage for that in your new policy, or else you might unintentionally be creating a gap in your coverage.
Right. Well, thanks, Ken. Devil's in the details with regards to the policies, and you're right. The policies are long. You got to read them. Barry Kwasniewski with our office likes to read insurance policies. Not many people do, but that's a particular talent that he has. As a follow-up, Ken, what obstacles face a charity or a not-for-profit in being eligible for D&O coverage, effective coverage?
Well, we find that organizations involved in certain kinds of activities like land or property development schemes, including through bare trust arrangements, or organizations who fail to have robust employment practices and protocols in place, or organizations that are having financial hardship, including a lack of liquidity, recurring operational deficits, or a negative net equity or fund balances, as they're known in the charity and not-for-profit accounting world. Insurance underwriters understand that not-for-profits will sometimes experience operational deficits, and they're not necessarily sitting on stacks of cash, of course. But if there's a pattern of financial stress reflected in the audited financial statements, it means the organization's at a much higher risk of fiduciary, financial, and wrongful dismissal claims, which can render them uninsurable or limit their options for certain coverages under a D&O policy.
Great. And Ken, we've got about 6 minutes left. We got about two or three questions left, so some time here. This brings us back to the thorny issue of cutting corners instead of buying the coverage organizations and boards really need. And to your earlier point about frequent versus severe risk, can you give us some examples from your experience over many years and what budget trade-offs might be considered in choosing insurance coverage for the organization and to protect directors from uninsured personal liability?
Well, organizations that have limited budgets and significant risk should seriously consider strategies where they do things like going with higher deductibles. So instead of paying the first $1,000 in a claim, they should consider $5,000 or $10,000 deductibles for things they can handle. From our years of experience, our organizations suffer a claim on average about every 8 or 9 years. So if you save premiums for 8 or 9 years with deductible savings, it does give you some premiums to pay for things that you might not have thought of, but that can come back and bite you. So fundamental principle of insurance is to transfer risks that have outcomes that you as an organization simply can't afford, like a major fire, flood, hurricane, tornado, or a multi-million-dollar lawsuit. Therefore, you should be paying pretty close attention to the amount of liability insurance that your organization carries. For D&O policies, the highest award I'm aware of, and Terry, you may have different information, against a not-for-profit or charity that's a D&O type claim is just under $3 million. And for that reason, most not-for-profits carry D&O coverage of between 2 and 5 million. But by contrast, we've now seen 4 general liability lawsuits, awards, or settlements in excess of $10 million. All involved bodily injuries or deaths to a person or multiple people from the negligence of the organization. One was a fall by a volunteer from a roof during maintenance. One was during a sports recreational activity. One, an auto accident with passengers in a private vehicle going to a sponsored event. And one was on a trip outside Canada. So bodily injury is the risk with potential for by far the highest amount of damages in a lawsuit. And most insurers only provide anywhere from 2 to 5 million general liability. So the solution here is from maybe the dollars you save for raising your deductible to purchase an umbrella liability policy. It can give you an extra $5 or $10 million protection where you really need it. And there's a myth I'd like to bust that big organizations require a high amount of general liability and umbrella protection, and smaller organizations only a small amount. That's a complete misconception. It's wrong. It would assume that the same injury victim that's sitting in a court and confined to a wheelchair who's now paraplegic would only be entitled to a teeny tiny little award if their injury happened due to the negligence of a small charity, but a whopping big award if it happened because of a large organization's negligence. We know that's not true. So 3 of the 4 bodily injury claims above 10 million I mentioned earlier happened at charities with annual revenue of $250,000 or less.
Wow. Okay, and just to go over another topic, what about cyber insurance protection? Do you have any thoughts on the the importance of that?
Well, certainly it's been stressed today already, as emphasized by Bruce and in the AI segment today. Now, this will be the 3rd reminder emphasizing data protection as a major priority in the not-for-profit sector. And there's no doubt and denying the threat and cost of cyber crimes. It can't be ignored any longer, even among nonprofits. Cyber attacks are absolutely the fastest growing crime in the world. However, many people have a false sense of security in thinking because they've never experienced a cyber incident, they don't need to be concerned, or because they're a not-for-profit, they're not a target. In fact, your organization likely has assets that criminals value, including sensitive data and money. Your organizations might use digital systems such as computers, internet to store data about employees, volunteers, donors, program participants, engage in online banking, e-transfers, wire funds based on digital instructions, deliver online programs, services, support, and so on, and including fundraising and soliciting.
It's a real challenge, a real need there. Ken, just to move you over to the importance of directors of charities and not-for-profits fiduciary duty to protect property your thoughts with regards to the problems that can be encountered with regards to inadequate insurance concerning insuring property of a charity or not-for-profit.
Yeah. The focus tends to be on liability and liability suits. And while it's a key concern, you got to remember that over 75% of total premiums paid for many organizations is premium towards claims for property damage. And it's often the policy exclusions or limitations, insufficient coverage amounts for buildings, contents, that causes leaders some of the biggest headaches. And one thing that I'll just point out, it's the co-insurance clause, a standard provision in a property policy. It's usually stated as a percentage 90%. It's the minimum threshold that your property needs to be insured to avoid either an underinsured total claim or what's known as a co-insurance penalty in a partial claim.
Okay, Ken, thank you for that. Finally, I want to get some tips. You're an insurance broker, and all the folks on the on the webinar today are, organizations looking to work with an insurance broker. Do you have any tips, any suggestions of what to do when working with an insurance broker?
Well, in addition to the tip sheet, which will summarize some of the subjects we discussed today, some we didn't have as much time to talk about, but you'll see I've included at the very end a bottom line slide as a reminder the importance of working closely with your insurance provider as a partner. Including keeping them fully informed to be able to give you their best advice and avoid coverage gaps for your organization. And in turn, you should be expecting professional advice and written replies on important matters for your leaders to rely on and act on. And although you might want to delegate insurance coverage, research to a CFO, executive director, or treasurer, someone in your organization, remember, it's your organization's directors and officers whose necks and personal liability are financially on the line. So remember, your board should regularly review the insurance protection you have, including the fine print, because not all insurance policies are created equally. And you don't want to be put in the position as an organization or personally as directors to be self-insuring an underinsured claim or a multi-million-dollar lawsuit.
Ken, really good advice, and you've included in the materials the 5-point tip sheet. So thank you for that, together with some tips in working with the insurance broker. So that's very helpful to have, and just put it up here just to show folks that it's there. Ken, you've been just a wealth of information. Thank you so much. 35 years of experience in this area. Insurance is so important. And it often is sort of delegated down to a staff person, but you pointed out it really is important for the board of directors to be actively involved in reviewing the insurance coverage. So thank you so much, Ken, for the tips that you provided. Just excellent. We much appreciate it. Thank you.
Thank you very much, Terry, for having me. Appreciate it.
We're going to move over to the question and answer period. So we've got 14 of our lawyers available, and in the next 15 minutes, we're going to deal with as many of the questions that we can, with all 14, trying to get 2 questions in as we go. So first one for you, Esther. Esther Shaneblum, this is under Essential Charity Law Update. What's the difference between a charitable organization and an NPO? One of our attendees asked.
That's a great question. So aside from this, can you hear me?
Yep, and great, and 30
Okay.
seconds, 30 seconds or less.
They're incorporated under different provisions, or not incorporated, but their status is provided under different provisions. Charities and NPOs are both tax exempt, but charities are actually able to issue donation tax receipts. NPOs are not, and they have different reporting obligations to the to CRA. That's it in a nutshell.
Okay, that's good. And then Urshida, from the same topic, your Essential Charity Law. Why is the duty drawback a proposed part of the budget? What's the reason behind it? Can you explain that? That's one of the questions.
Yeah, sure. Yeah, thanks, Terry. The duty drawback program, which is the obsolete and surplus goods program, it's expected to help frontline charities and low-income individuals who rely on charitable support for essentials like clothing or household items, such as those. And these individuals, low-income ones that we're talking about, are those who might be out of work or working multiple part-time jobs or living with mental or physical illnesses. So the program has helped to support them.
Great, thank you. Now we're going to go over to navigating charitable registration. So a question for you, Jackie, that's come in. What is your general recommendation on seeking pre-approval of new purposes from the CRA versus getting the new purposes formally in place with a charitable corporation right away? 30 seconds or less.
Date of the current purposes of the charity. If they are really out of date, don't fully reflect your programs and activities, and you want to ensure you have full corporate authority, you should put them in place right away through the corporate changes and then advise CRA. If though there are new programs and you want to make sure you have new purposes, proper purposes in place, then I would say CRA pre-approval would be the way to go.
Thank you, Jackie. And Jeffy, this is a good question. Do I need to get a lawyer to apply for charitable registration or re-registration? Jeffy?
I like to think of it like building a house. With all the information available online today, you could probably build a decent house with some help from friends without hiring any qualified personnel. But whether that house passes inspection or stands the test of time is another matter. So it's possible to apply for charitable registration on your own. A lawyer, especially one with experience in the charitable and nonprofit sector, can help ensure your foundation is solid. Charitable registration is not just about getting CRA approval, it's part of a much larger structure.
Great, thank you, Jeffy. Over to you, Barry, on the legal considerations of hiring process. The question is, if we have a current employee and we want them to sign a new employment contract, is that possible to do?
Yes, it is possible to do, but you have to be careful in how you do it, because since there'll be changes in the employment contract, and an employment contract is a two-party agreement, you have to get the employee's consent to the change, and you also have to provide the employee with something that is called consideration. That's a legal term meaning something of value. So the typical consideration for signing a new employment contract would be, for example, a one-time signing bonus or a raise in pay or some other benefit of value to the employee.
Okay, thanks, Barry. Over to rebranding. Sepal, the question is, if our organization is planning a rebrand but will not launch publicly for another year, is it too early to file a trademark application now?
Yeah, that's a great question. And the long and short of it is it's never too early to file a trademark application. We are a first to file system in Canada. So the sooner and earlier you can get your application in with the Canadian Intellectual Property Office, the better in the long run.
Great. Okay. And Esther, the question says, we are thinking about changing our name, but are just in the initial stage of discussing what our new name might be. Do I need a lawyer to carry out the name searches that Esther mentioned in her presentation?
So it's good to be doing your homework in the very initial stages. The name searches, particularly the preliminary ones I mentioned in my presentation, you do not need a lawyer to get those done. There are various third-party service providers whose websites you can find online. Just be careful before you click on the service. We had one client ask us why the government is now charging $200 to file a director change form. And it turned out it was a third-party service provider that was doing that made their website look like a government one. So just make sure you check the prices before you click on anything.
Okay, good. Thank you. Over to disbursement quota. Teresa, the question is, what is property? Dash cash investments or real property? Question mark. What is property?
Under 30 seconds? Yes, all of it. Anything that you set aside, it can be money in the GIC, it could be mutual funds, anything that you're not using currently in your programs or administration. So everything you just talked about.
Okay. Good answer. Thank you. Then over to AI, the Brave New World. Question for you, Martin. It says we're a small charity and our staff barely uses AI tools. Maybe just to draft an email or summarize notes. Do we really need to spend time developing a formal AI policy at this stage?
Well, we did cover that briefly at the end of our presentation there with the simple AI policy. So we do recommend, even if you're a small organization, you have something in place, something just minimal. And again, that's just basic standard due diligence and accountability. So that gives you then something to work from, and then you're not caught flat-footed if anyone complains about perhaps, that they didn't realize that you were using AI or something like that. So generally, yeah, smaller organizations, it's we understand the challenges, and we do recommend at least a minimalist policy to have in place.
Okay, good. Cameron, over to you. Our question is, our board is interested in using AI to increase efficiency, but they're also nervous about data breaches or misinformation. How can we encourage responsible use without shutting down innovation?
That's a great question. So building off what Martin had said, proper policy, even a bare bones one, it's going to have enough guidance to keep your organization safe from any of the foreseeable issues. The policy, it needs to emphasize human oversight, like we keep drilling down on. AI should support and not replace human judgment. And you should pilot AI in low risk environments where any sort of issue or error in outputs are going to be easily detectable.
Okay, great. Thank you. Okay, we're going to go over to the dirt lawyers. Nancy, here's a question for you. What's the single biggest takeaway for boards from all of these property law updates that you've given? I need to get some clarity. So over to you, Nancy.
Thank you. I'm going to probably give the lawyer answer. It's board governance, making sure that you're properly recording and documenting all the property law decisions to ensure compliance and avoid, financial and reputational risk in the future.
Okay, good. Thank you for that. And Adriel, the other dirt lawyer, does Bill C9 actually change how charities or faith-based organizations manage their property, or is it mostly symbolic?
Oh, yeah, for sure. It absolutely, changes how they manage their property, because what it does is it adds some concrete criminal law protections for different places, like places of worship, schools, community centers, different that are used by identifiable groups. So it's going to enable faster police response to hate-motivated intimidation, and it's going to strengthen the legal framework around how properties are accessed and just how safe properties are kept. So it's definitely a good prompt to review your incident response and security policies.
Okay, thank you for that. So we're going to go over to Ryan, the bun fight in the family. And Ryan was hoping for some tough questions. I got one here for you, Ryan. Can a member proposal include a resolution to remove a director?
That's a good question. It's not something that the statute speaks to specifically, either with the CNC or ONCA. Proposal rights do include anything that a member could bring up at a meeting. And normally the removal of a director requires some notice. So a proposal could certainly include removal of a board member, which the board would then have to circulate in the notice for that meeting. But they could also do so by requisition in a meeting and indicating that the business of the requisition meeting is going to be removal of a board member as well.
Okay, good. Now, we're not going to have time for a second question for everyone, so I'm just going to do some arbitrary questions, no particular priority on it. But for you, Jackie, I've got a question that's come in. What is the process of obtaining consent to leave out the after acquired clause in your certificate of amendment with regards to the ONCA? So, Jackie, can you give us a brief answer on that?
Yeah, basically you need to write to the PGT. They have a general email address where you send in inquiries and requests such as this one to have a consent to not include the after acquired clause. You will, with your letter asking for that consent, you have to provide the corporate documents in question, the historical documents that show the existing purposes together with the new draft purposes that you're planning to put in place.
Okay, good. Thank you for that. And then, Sepal, I got a question for you that's come in. Do trademark registrations expire? You know this.
Yes, I know this one. It's a good one. And I should have probably mentioned it, but once you're registered, your trademark is good for 10 solid years. After that, you'll need to renew it with just a simple payment of some government fees. So
How long?
for another 10 years.
Okay, listen up, Terry. Okay, thank you. So, Teresa, and you may be the last one here. So in meeting the DQ disbursement quota, The DQ is based on global DQ calculations, but some of the sector promotes DQ on a fund-by-fund basis. What are your thoughts on this? And maybe you kind of explain that question, if you could, for the audience.
I explained what global calculation means because the example that I gave, the 60,000 the dispersed DQ obligation, you don't have to dip into the investment. You can spend it from your operating account. A fund by fund thing, if I could be a profit, I would highly encourage, do not go there. Because if it's on a fund by fund basis, think of like a university. It has many funds. So that means you have to go into each fund, the hundreds of funds, and calculate the 5%, 3.5%, and then disperse from that fund. It's going to be an administrative nightmare. I don't see any need for that. So I would persuade, the politicians, don't go there.
Thank you, Teresa. And that's it for our questions, Q&A. By the way, if there's any questions that folks have for Ken, feel free to send them in. We'll send them along to Ken, and he's indicated he's happy to answer them afterwards. But I want to really thank all of the presenters for their participation today and for their excellent topics and for answering all those tough questions at the end of the day. So as we sort of wind down now to keep on target for 1:15, I do want to again thank Bruce McDonald for being part of the presentation, the webinar today, together with Ken Hall. And we've got all of the speakers that have presented, which I won't mention their names, they're there before you. I do want to, though, give a real attention to our support team, because we wouldn't be able to do this without them. Audrey Ferreira, Lauren Haythorne, Monica Keller, Jennifer Kirchhoff, Brenda Parsons, Sunil Patil, Bruce Phillips, Wendy Speziali, Jen Thistle, Wayne Moen, and Marshall Brennan at EventStream, and as well for the help that we've had from Selena Natu, our articling student, putting together the PowerPoints. Also want to give a big thank you to our sponsors, Adam and Miles, Robertson Hall Insurance, M&P, Thomson Reuters, Beacon Endowment Solutions, and LexisNexis. Over to you, Ryan.
And now the moment you've all been waiting for. We're going to announce the winners of our door prizes. So the first up is the voluminous 4-volume set of the Thomson Reuters Corporate and Practice Manual for Charitable and Not-for-Profit Corporations. You'll want to have a sturdy shelf to put this one on, but that is awarded to Anna Chatter. So congratulations, Anna. Next over to our LexisNexis books. We have one copy of the 2026 Charities Legislation Commentary. As I said before, it's not even out yet. It's going to be hot off the press in December 2025. You can see Terry has one of the advanced copies there, and that goes to Paul Cassidy. Congratulations, Paul. Okay, now, next we're turning over to the Management of Nonprofit and Charitable Organizations in Canada, 6th edition, as I should have said before. So you're going to want the most current, up-to-date edition. And for that, the winner is Heather Perquin. Heather Perquin. Congratulations, Heather. All right. And last of the books, we've got from both Terry and CPAL, the Branding and Copyright for Charities and Nonprofit Organizations, 4th edition. And that's going to Marcel James. Marcel James. Congratulations to Marcel. And lastly, the $100 gift certificate for the 4 Cs. That's going to go to Carrie Thornton. Carrie, enjoy your shopping trip over at the 4 Cs website. Thank you.
Well, thank you very much, Ryan. And thank you for being a co-host. A lot of fun to work with on it. So much appreciated. And finally, just a heads up, in case you're planning ahead, the 2026 Carter's Annual Charity Not-for-Profit Law webinar will be held on Thursday, November the 12th, 2026. So put that in your calendar. Thank you so much for being part of our webinar today. We hope that's been of help. And again, on behalf of all of the lawyers and the staff at our firm, We do appreciate the opportunity of working with all of you in the charity and not-for-profit law sector. Thanks so much. Have a great day, everyone. Bye-bye.